The committee will come to order. Without objection, the Chair is authorized to declare a recess of the committee at any time. Today's hearing, the Federal Trade Commission and its Section 5 authority, prosecutor, judge, and jury. The Oversight Committee mission statement is that we exist to secure two fundamental principles. First, Americans have a right to know that the money Washington takes from them is well spent. And second, Americans deserve an efficient, effective government that works for them. Our duty on the Oversight and Government Reform Committee is to protect these rights. Our solemn responsibility is to hold government accountable to taxpayers, because taxpayers have a right to know what they get from their government. It's our job to work tirelessly in partnership with citizen watchdogs to deliver the facts to the American people and bring genuine reform to the Federal bureaucracy. And with that, I would recognize the Ranking Member for his opening statement.
Thank you very much, Mr. Chairman. Today's hearing will cover several new issues for this committee. First, the Republican briefing memo says that the committee will examine, quote, whether the FTC has the authority to pursue data security enforcement actions under its current Section 5 authority. In Section 5 of the FTC Act, Congress gave the FTC authority to protect American consumers, that is, our constituents, and ensure that their personal, medical, financial, and other information is protected from unauthorized disclosure. The FTC has been using this authority to ensure that companies who receive this type of consumer information take appropriate steps to safeguard it. In fact, a Federal judge recently upheld this authority and rejected an attempt to, quote, carve out a data security exception, end of quote. Yesterday, Senator Rockefeller, the chairman of the Senate Commerce Committee and an expert on this issue, sent a letter to the chairman emphasizing this point. He wrote, and I quote, "Another apparent purpose of your hearing is to express skepticism about the FTC's long-standing and well-established legal authority under Section 5 of the FTC Act. This skepticism is unfounded, and your public position was recently rejected by a Federal judge in the FTC data security case against Weinman Corporation." He goes on to say, over the past 13 years, the Commission has initiated dozens of administrative adjudicatory proceedings and cases in Federal court challenging practices that compromise security of consumers' data and that resulted in improper disclosures of personal information collected from consumers, end of quote. According to the Republican memo, today the committee will also examine, quote, recent FCC actions related to data security practices, end of quote. One of the witnesses testifying today, Michael Daugherty, the CEO of a company called LabMD. The FTC has brought an enforcement action against LabMD, and Mr. Daugherty admits that more than 900 files on his billing manager's computer were accessible for public sharing and downloading, which is a major security breach. Mr. Daugherty has written a book entitled "The Devil Inside the Beltway." In it, he refers to the FTC as, quote, terrorists, end of quote. He also accuses the FTC of engaging in, quote, psychological warfare and torture, and of administering government chemotherapy, end of quote. Of course, he has a right to his opinion, but this committee should base its oversight work on facts rather than extreme rhetoric of a defendant in an ongoing enforcement action. As part of our investigation, we have also received competing allegations about Taversa, a data security firm that provided information to the FTC about LabMD's security breach. Obviously, we all agree that the FTC should rely only on evidence it believes to be legitimate. If allegations are ultimately verified that Tyversa provided intentionally falsified data, that data clearly should not be used in any enforcement action. But to date, we have obtained no evidence to corroborate these allegations. So they remain just that, unconfirmed allegations. Unfortunately, on June 17th, the Chairman sent a letter to FTC Inspector General alleging coordination and collaboration between the FTC and Tyversa and suggesting that, quote, the FTC aided a company whose business practices allegedly involved disseminating false data about the nature of data security breaches, end of quote. Chairman wrote that, quote, the FTC appears to have acted on information provided by Tyversa without verifying in any meaningful way, end of quote. He also requested that the Inspector General examine the actions of several specific FTC employees. I do not know how the Chairman could have reached these conclusions since the committee has not yet spoken to a single FTC employee. The committee just requested documents from the FTC less than a week ago, and the committee has obtained no evidence to support claims that the FTC officials directed Tyversa employees to fabricate information. To the contrary, every single current and former Tyversa employee interviewed by the committee staff has uniformly denied receiving any requests from FTC employees relating to fabricating information. In response to the Chairman's request for an investigation, the Inspector General has now informed the committee that one of the employees named in his letter, in fact, was, quote, brought in to assist with the LabMD case after Tyversa was no longer involved, and she has not been working on the case for the past year, end of quote. As I close, so it appears that some of the Chairman's information was incorrect. I'm sure we will hear a lot of allegations today from parties in this ongoing litigation. Our job is not to take sides, but rather to serve as the neutral overseers and base our conclusions on the facts and the evidence. The consequences of having personal information compromised can be devastating. As the new Republican Majority Leader, Kevin McCarthy, has said, and I quote, nothing can turn a life upside down more quickly than identity theft, end of quote. I agree with him. That is why I wrote to Chairman Nice in January proposing that the committee examine the massive data security breach at Target, which may have compromised the personal information of more than 100 million American consumers. Instead of holding hearings like today's, which seeks to cast doubt on whether the FTC even has the authority to protect our constituents, the consumers, the American consumers, I hope the committee will turn to constructive efforts to improve corporate data security standards across the board. And I thank you, Mr. Chairman, for your courtesy.
I thank the Ranking Member. Today's hearing concerns the Federal Trade Commission and information this committee has uncovered that raises some important questions. As long as I have been Chairman and as long as I am Chairman, this committee will focus, as its name implies, Government Oversight and Reform Committee. It is not for us to look first to the private sector. It is not for us to issue subpoenas and target private sector for their beliefs, for their practices, or for the failures that they certainly are paying a high price for, as Target is and should. During my tenure, healthcare.gov was launched. Anyone of ordinary skill could have gone in to the website, changed a few statements, a few of the letters in the top of the screen while looking at their record, and seen somebody else's record at the launch. On a $1 billion web design, it was vulnerable to ordinary hacking and accidents at the time it was launched. The FTC did not sue President Obama or any of the chief information officers responsible for this failure. They did not sue the Secretary. They did not even sue the companies who delivered this shoddy work. Instead, these were systematically, when discovered, corrected at taxpayers' expense. That was the right thing to do. When mistakes are made, when vulnerabilities are recognized, it's the responsibility of the entity to do its best to fix them. If the Federal Trade Commission was overseeing companies whose vulnerabilities are exposed, demanding that they fix it or face the consequences, absolutely, we would say they were doing their job. If the Federal Trade Commission had even published a best practices minimum requirement for data security, we would be able to say that the law was clear and that somebody failed to live up to those stated guidelines. But none of these exist. The Federal Trade Commission cannot tell you what's right. They only will come in and demand a consent decree if, in fact, you, through fault or no fault of your own, become a victim of hacking or a recognition of a vulnerability. The FTC is using its regulatory authority not to help protect consumers, but in fact to get simple consent decrees using the unlimited power it has to not only sue at government expense, but to force you before administrative law judges that in fact are part of the executive branch. Millions of dollars will be spent attempting to defend yourself against the Federal Trade Commission, even if you are right. And what if you're wrong? What if you're wrong? What if something happened? What is your choice? Several years ago, under Chairman Waxman, I watched a demonstration of a vulnerability created by a third-party software that people were using to share music. I'm a techie. I was impressed. I saw that this software was downloaded by hundreds of thousands of people, put onto computers they owned or didn't own, and it created a vulnerability. It was deceptive, at least according to testimony. It was deceptive in how it did it, and our own people loaded the software and agreed that when you loaded it, the default would make the hard drive of the computer it was loaded on vulnerable in every one of its directories, when in fact you were really only attempting to make your music directory available for sharing. In both public and private systems around the country, this software was downloaded and created what people thought was a peer-to-peer music sharing, and in fact created a vulnerability in which people could look at what was on your hard drive. We were aghast. We thanked our witnesses for making us aware of it, and we committed ourselves to stop the deceptive practice of this software company, something over which the FTC had authority and should have acted. But in fact, what we are finding is that what we were told was only a part of the story. What information does the question today is, how is the FTC using that regulatory authority, and are they doing their job? Are they targeting the culprit or the victim? What information does the agency consider to be reliable basis to embark?
Mr. Chairman, could I ask you why the clock's not running on any of this?
We didn't stop the chairman, the ranking member, from going as long as he wanted, well over the time. That's the practice of the committee. Thank you.
That's a good answer. Thank you.
What information does the agency consider to be reliable basis to embark on often erroneous inquisitions, in the chairman's opinion, into the activities of American companies? The committee held two hearings in the past, as I mentioned, one in 2007 and another in 2009, about the potential for individuals using peer-to-peer file-sharing programs to inadvertently share sensitive or otherwise confidential information. The key witness in both of these hearings was Mr. Robert Bobek, the CEO of a cyber intelligence firm, Taversa Incorporated. That CEO outlined numerous data breaches that deeply troubled members of the committee. Mr. Bobek specifically spoke about an open-door clinic, a nonprofit AIDS clinic in Chicago's suburbs in 2009. He said, and I quote, "These are AIDS victims, 184 patients, who are now victims of identity theft. The clinic released their information and has not addressed it. But the Open Door Clinic has told us they have no information of any of their patients having had their identity stolen. We do not know why Mr. Bobeck made the claim to this committee previously, and we will hear that today. Earlier this year, this committee became aware on a bipartisan basis of serious accusations that Traversa engaged in a business model that was not focused on protecting consumers alone, but obtaining what we would say effectively is a new form of protection payments from businesses. As is often the case with protection payment demands, many businesses that did not pay up face serious consequences. Here's how it worked. Traversa would contact a company or organization and tell them that they had engaged in a practice that left customers' data vulnerable. Traversa would offer to sell the company or organization remediation services. Many companies took their services and paid, at least for a while. Others refused and found themselves turned over to the Federal Trade Commission. The cost and concerns created by an FTC investigation can be immense, particularly to a small business that in many cases were the ones that Traversa focused on. But this isn't just about allegations of unethical corporate behavior. The committee has asked the Federal Trade Commission to provide us with evidence that it independently verified information provided by Traversa about businesses before pursuing action. As the ranking member said, it's been a short time. But having engaged in suits, received consent decrees, and litigated for years, we expected that the Federal Trade Commission would be able to give us at least a few examples of independent confirmation immediately. We are still waiting for the FTC to show us such evidence. We look forward to it, and as I will say again, we look forward to hearing from the FTC in the future directly. It's one thing for a company like Traversa to report all of its concerns about consumer data breaches to appropriate authorities. It's quite another when enforcement authorities are selectively used through a special relationship to punish firms who refuse to pay for those services. The committee has reason to believe that information provided by Traversa on which the FTC relied was inaccurate. Two of our witnesses this morning were approached by Traversa and the FTC regarding data breaches. Traversa provided information that alleged data breaches in these organizations about these breaches in these organizations to the FTC only after they refused to sign up for Traversa's services. Mr. Doherty, the CEO of LabMD, according to my opening statement, has been to hell and back. I don't think he's gotten back yet. In fact, his fight with the FTC has gone on for years. The Commission wanted him to acquiesce to a consent decree admitting that he did not take proper precautions to avoid data breaches. Given that Mr. Doherty did not believe the allegations against him were true or fair, he fought back, and he did so at great personal expense. His specialized cancer screening company is now effectively non-existent. I will let Mr. Roessler explain his experience with Traversa and the tribulations he experienced thereafter. But I especially want to thank him for being here today. Mr. Roessler runs as previously mentioned, a nonprofit AIDS clinic near Chicago, Illinois, and has taken time away from his important work and agreed to join us this morning because of how important he believes it is to tell his story. I also want to thank Mr. Stegmeyer for appearing this morning. He will be providing invaluable testimony about the FTC's actions as they relate to going after companies that alleged to have unfair deceptive trade practices. Today's hearing is an opportunity to hear from alleged victims of these arrangements made between Traversa and the Federal Trade Commission. Neither the FTC nor Traversa are here today, but I do expect to have both of them here at a future date to respond to the concerns and allegations that I expect we will hear today. Today's hearing is the result of a whistleblower who, at great personal expense, came to this committee. This committee is grateful to all the brave individuals who come forward to provide information as whistleblowers. It's only through whistleblowers that we see an exposure of wrongdoing by the government as well as private companies. Whistleblowers are not always without responsibility. Whistleblowers may, in fact, know what they know because for a time they participated in the wrongdoing. Nevertheless, whistleblowers are invaluable. When someone's conscience, whether they were involved or not, brings them forward, they should never be the target of this committee. This whistleblower gave us a proffer seeking immunity only for what he was to testify to that he had done on behalf of Traversa. He detailed for this committee information that was invaluable to our ongoing investigation, which is only ongoing because of his coming forward. At a point in the future, I expect this committee will need to schedule a vote on granting immunity for this whistleblower. To date, we have not been able to convince the minority to consider immunity for this whistleblower. Instead, at every turn, the minority has chosen to seek accusations against the whistleblower against his personal wrongdoing, his personal misconduct, his personal life. But in fact, to our knowledge, no evidence has come forward that would in any way dispute the accuracy of the detailed story that he told. For those members here on both sides of the aisle, if you have not already seen his video proffer of how he participated in the activity, I ask you to schedule time, members only, to see this proffer. Because as we consider immunity, it is important that you understand the nature and detail of the evidence and accusations brought by this whistleblower. I make no credible statement as to a whistleblower's authenticity. What I can say in this case is, without the whistleblower, we would not be having this hearing today. And if the whistleblower is guilty of a crime, the crime had to be committed by others that he is accusing. There can be no crime if, in fact, he is not telling the truth. And if he is telling the truth, he participated in a deception that affected both the Federal Trade Commission and the United States Congress. I would ask all members, please take time out of your busy schedule to view the proffer. It is detailed. It takes nearly an hour. But it will lead, I believe, to the kind of recognition that you cannot see here today in an open hearing. It is now my honor to welcome our witnesses. Mr. Michael Dougherty is the Chief Executive Officer of LabMD, Inc. Mr. David Rossler is Executive Director of Open Door Clinic in Illinois. Mr. Gregory Stegmeyer is a partner at Goodwin Procter in D.C., in Washington, D.C. And Mr. Woodrow N. Hartzog is an Associate Professor at the Cumberland School of Law at Stanford University. Gentlemen, pursuant to the committee rules, would you please rise to take the oath and raise your right hand? Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Please be seated. Let the record indicate that all witnesses answered in the affirmative. For our first two witnesses in particular, you're here to tell your story. I know testimony is new to you. We have a 5-minute rule. Your entire opening statements as prepared will be placed in the record, but I understand that you may go over slightly. We're not going to hold you exactly to 5 minutes, but to the greatest extent possible, try to stay within the 5 minutes, which will help us ask you more questions in follow-up dialogue. Mr. Doherty.
Thank you. Good morning, Chairman Issa, Ranking Member Cummings, and members of the committee. My name is Michael Doherty, and I am the President and CEO of LabMD, a cancer detection laboratory based in Atlanta, Georgia. We were a private company that I founded in 1996, a small medical facility that at its peak employed approximately 40 medical professionals who touched nearly 1 million lives. Thank you for the opportunity to speak to you as a small businessman and medical professional about my experience and opinion at the hands of the Federal Trade Commission. What happened to my company, its employees, physicians, and their patients is what springs from the FTC's unsupervised playbook. And that playbook relies upon coercive and extortionate strategies to make large and small companies alike quickly succumb to FTC demands. In May 2008, our nightmare began with a call that could happen to any American. It was from Robert Baubeck, the CEO of Tyversa. And in the words of former FTC Commissioner Rausch, Tyversa is more than an ordinary witness, informant, or whistleblower. It is a commercial entity that has a financial interest in intentionally exposing and capturing sensitive files on computer networks. Mr. Baubeck told LabMD that Tyversa had found LabMD patient data on the Internet but refused to tell us more unless we paid and retained them. Everyone in medicine knows you cannot go out intentionally looking for vulnerable medical files so you can take them, read them, keep them, distribute them. This is probably a crime, but it's definitely vigilante behavior, and it's outrageous. In January 2010, Alan Shear, an attorney with the FTC, contacted LabMD with an 11-page, single-spaced letter opening a non-public inquiry. We responded by sending in nearly 10,000 pages of documents, and we invited the FTC to come to Atlanta to see our facility, to tell us what we were to do differently, to tell us what their standards were. The FTC declined. We quickly discovered that until told otherwise by the courts or Congress, the FTC presumes to have jurisdiction to investigate any company or person. When we asked the FTC where they were going with this, they would obscurely mention consent decrees, and we learned that FTC consent decrees actually are this. You sign up for 20 years of audits, you enter the FTC Hall of Shame via craftily worded press releases and half-truth congressional testimony. The fact that you've not been found of any wrongdoing stays buried deep in the fine print, and the threat of being tied up for years in court and drained financially is their gun to the head to extract false confessions. In August 2010, I had to find out what was going on here because something felt odd and wrong, and I learned that Homeland Security gave $24 million to Dartmouth to partially fund their data hemorrhage study, and Dartmouth stated that it got the LabMD file by using Tyversa's unique and powerful technology. Tyversa put out a press release in May 2009, I found, which in part stated, Tyversa, and this is their words, Tyversa today announced the findings of new research that revealed 13 million breach files emanating from over 4 million sources. Tyversa's patent-pending technology monitors over 450 million users issuing 1.5 billion searches per day. Over a 2-week period, Dartmouth College researchers and Tyversa searched file-sharing networks and discovered a treasure trove. A spreadsheet from an AIDS clinic with 232 client names, a 1,718-page document from a medical testing laboratory, and requiring no software or hardware, Tyversa detects, locates, and identifies exposed files in real time, end quote. What does Tyversa want you to think exposed means? Out of 13 million files found by Tyversa, how odd is it that the two mentioned in their press release are sitting at this table today? I was stunned that nobody was asking who this private company was who was stockpiling other people's sensitive information. What gave them the right to assume ownership? September 2013 to April 2014, the FTC pursued litigation against LabMD via their optional administrative process rather than in federal court. FTC Commissioner Wright said this process provides the FTC with institutional and procedural advantages. This is lawyer speak, for the FTC stacks the deck way in favor via rules Congress allows them to make. They admit hearsay that would never fly in federal court, which is why we aren't in federal court. Federal courts won't intervene because Congress says they can't. When asked about the FTC data security standards, Alan Scheer said, and I quote, "There is nothing out there for a company to look at. There is no rulemaking. No rules have been issued. Yet even without any standards, they show others what happens if you push back. They subpoenaed approximately 40 different individuals in my company, long-gone LabMD employees that left the company up to 7 years before, current staff, managers, outside physicians, vendors. These witnesses were forced to retain counsel and were intimidated and scared. Here is the message to all that are watching from the FTC. This is FTC justice, and this is going to happen to you if you don't play along." And then the penny dropped. During the trial, a former Tyversa employee who was to testify regarding Tyversa's acquisition of LabMD data and subsequent submission of the data to the FTC invoked his Fifth Amendment right against self-incrimination. All Americans should be outraged by the FTC's unchecked ability to pursue a claim that is not based on any legal standard. Outraged that the FTC's administrative proceedings do not afford the same guarantees of due process that our federal courts provide. And outraged with the FTC's use of and reliance upon information from a private for-profit entity. If this has happened to LabMD, a small medical facility, a cancer detection center, this can happen to anyone. This does nothing to help Americans adapt to the constantly changing cybersecurity landscape. We are not mind readers. We are law-abiding citizens. I call on the FTC to stop attacking victims of crimes, and I thank the committee for its time and attention to this matter.
Thank you, Mr. Roessler. I'm sorry. You're finished, right?
Oh, yeah.
Thank you. Mr. Roessler.
Good morning, committee members. My name is David Roessler. I am and have been the executive director of Open Door Clinic in Elgin, Illinois, the far western suburbs of Chicago, for the past 15 years. I'm appearing today in response to an invitation to testify on behalf of Open Door regarding its involvement with the FTC and a company called Tyversa. Between September of 2008 and March of 2013, Open Door was involved in a class action lawsuit due to a file that was found on the internet that contained names, some with social security numbers, some with addresses, some with birth dates. Open Door is a small, not-for-profit AIDS organization. Currently, we have about 30 employees. We had about 15 during this time. We provide medical care, support services for our clients. In July of 2008, a company called Tyversa contacted Open Door and said that they had had access to a confidential document obtained from a P2P network on the internet. Communications with Tyversa included a contract for services. The suggested fees for the contract were $475 an hour. We contacted our IT service provider, who researched our network, found no evidence of any P2P networks at that time. In September of 2009, Tyversa contacted Open Door again to report that documents were still available on the P2P software. Open Door's IT provider once again reviewed its network to confirm that there was no evidence of any P2P software at that time. 2 months after that, in November of 2009, clients began calling their case managers at the clinic, reporting that they were receiving phone calls from a law firm asking them to join a class action lawsuit because their information had been released by Open Door. At Open Door's November board meeting, shortly after the client started calling, one of the board members is the client. He brought in a letter that he got in the mail also from this out-of-state law firm telling them that they had their information out on the internet and would they join a class action lawsuit. Then in January of 2010, we received a letter from the FTC. The letter indicated that they had found a file on a peer-to-peer network, and it had a different title than the document that had been reported found by Tyversa. Also in January, that same month, in 2010, Open Door was successful at getting a law firm to provide us some pro bono work to help us understand what our compliance and responsibilities were. Open Door and its IT provider once again reviewed our network, all of our workstations, to confirm that there was no P2P software at that time. In February, a month later, February of 2010, a class action lawsuit was filed in Kane County against Open Door. Sensational newspaper headlines, numerous media outlets began showing up at our door. And 3 years later, Open Door settlement agreement was approved by the court, dismissing the class action. Open Door and its insurers agreed to these motions. Open Door denied and continues to deny any legal responsibility for the disclosure. Had the case been tried, we would have expected to prevail, but because of the uncertainties, the expense of litigation, Open Door and its insurers agreed to terminate this litigation under these terms. Thank you for letting me tell my story.
Thank you, Mr. Stegman.
Mr. Chairman Issa, Ranking Member Cummings, members of the subcommittee. My name is Jerry Stegmeyer, and I'm pleased to be here today to discuss the Federal Trade Commission's data security enforcement activities under Section 5 of the FTC Act. The views I express are my own, not of our clients or of our firm. I'm a partner at Goodwin Procter LLP and an adjunct professor at George Mason University School of Law, where I've taught privacy, consumer protection, and constitutional law courses for the last 13 years. I regularly appear before the Federal Trade Commission, state attorneys general, and assist businesses with all aspects of their privacy and information governance concerns. I appreciate the opportunity to appear before you today. In 2013, there were 63,437 reported security incidents and 1,367 confirmed data breaches. That is not a number reporting the number of accessible information, which is one of the things that Mike spoke about. According to Verizon's 2014 data breach investigation report, 44 million data records across the globe have been exposed. Companies are aware of the need for data security and have taken steps to be more secure. Data security is important to consumers, the economy, and business. But equally important is the basic constitutional principle that people have a right to know what the law expects of them before we prosecute them. I think a simple analogy helps illustrate this in practice. When we want people to regulate how fast they drive their cars, we post speed limit signs. If you violate that posted limit and the sign has been there for more than 60 days, you'll likely receive a citation. The law calls this fair notice, and the Constitution protects us from government overreach with it. It is the shield that protects us from the deference that agencies receive. While this analogy may not be a good one, it's important to note that it represents the feelings of many organizations that confront FTC enforcement actions relating to data security. The agency has offered no formal rulemakings or adjudications related to data security, and the FTC appears to regulate data security primarily through complaints and consent orders, as we've heard. Neither the complaints nor the consent orders are binding, reliable precedent. They are non-precedential. Some might call this stop-and-frisk black box justice. FTC complaints and consent orders are inconsistent and often lack critical information. For example, it is often unclear whether implementing some or all of the measures in a given order would result in fair data security or even serve to avoid future enforcement actions had the underlying company admitted them in the first instance or practiced them. The FTC's often repeated position is that security standards can't be enforced in an industry-specific case-by-case manner. Without more guidance, provides little comfort to those appearing before the agency. Because the FTC decides on an individual and post-infraction basis whether a company is non-compliant, the risk of enforcement actions is unimaginable and unpredictable, as we've heard. The penalties that may result from non-compliance are potentially ruinous. Combined with ambiguity of the law, unnecessary compliance risk for regulated entities has created a situation ripe for overreach, unfairness, and even an uneven application of the law. The FTC's existing enforcement and guidance practices also pose serious due process concerns relating to fair notice of the law's requirements. Current enforcement environment consists of aggressive enforcement against the victims of third-party criminal hacking who operate in a realm without clear and unmistakable data security law. Improved authoritative, and I emphasize authoritative, interpretations of Section 5 by the agency and the courts are crucial to improve compliance and provide entities with sufficient information to understand how to respond. Let me be clear. The FTC has the means to more clearly define the law and provide useful, reliable guidance. The existing tools are there. Sadly, there's plenty of room for improvement with the use of these existing tools, and improvements are essential to clarify the underlying uncertainty, which we've heard about, and more importantly, to address the constitutional issue of fair notice and due process. The current reasonableness test, absent additional flexible, principles-based authoritative guidelines or court-resolved litigation, will do little or nothing to clarify the data security obligations of companies. Using the standards reasonable and appropriate without articulating such factors as the nature of business, the kind of information collected, or any other factors may come into play may not ensure that fair notice occurs. In essence, we tell our clients, do what you say and say what you do. We need to hear from the agency what they're doing and what they're saying so that the people who are subject to prosecution can understand how to respond and how to behave in the first instance. The FTC itself has not consistently defined what sensitive information is, and without clarification, the agency's enforcement will continue to be perceived as arbitrary, and we will lack an understanding of reasonableness. I thank you for your time and attention. I'm pleased to answer any questions you may have.
Thank you. Mr. Hartzog.
Chairman Issa, Ranking Member Cummings, and members of the committee, thank you very much for inviting me to provide testimony today. My name is Woodrow Hartzog, and I'm an associate professor at Stanford University's Cumberland School of Law and affiliate scholar at the Center for Internet and Society at Stanford Law School. I am testifying today in my personal academic capacity and not on behalf of any entity. For the past 2 years, my co-author, Daniel Solov, and I have researched the Federal Trade Commission's regulation of privacy and data security issues, which I will collectively call data protection. We have analyzed all 170-plus FTC data protection complaints to find trends and understand what the FTC's data protection jurisprudence actually tells us. I would like to make 2 main points regarding what I've learned about the FTC's regulation in this area. First, the FTC's regulation of privacy and data security under Section 5 has served a vital role in the U.S. system of data protection. The FTC's involvement has given a heavily self-regulatory system of data protection necessary legitimacy and heft. The FTC also fills significant gaps left by the patchwork of statutes, torts, and contracts that make up the U.S. data protection scheme. The FTC's regulation of data protection also helps foster consumers' trust in companies. It is very difficult for consumers to determine whether a company has reasonable data security practices or not. The FTC's regulation of data protection helps give consumers confidence that their personal information will be safe and properly used. The second point that I would like to make is that the overwhelming pattern that is apparent from the FTC's data protection jurisprudence is that the agency has acted judiciously and consistently in outlining the contours of impermissible data protection practices. Section 5 of the Federal Trade Commission Act generally prohibits unfair or deceptive trade practices. This is an intentionally broad grant of authority. Congress explicitly recognized the impossibility of drafting a complete list of unfair, deceptive trade practices. Any such list is destined to be quickly outdated or easily circumvented. Despite this broad grant of authority, the FTC actually brings relatively few data security complaints, especially compared to the total number of reported data breaches. The Privacy Rights Clearinghouse has reported that since 2005, there have been over 4,300 data breaches made public, with a total of 868 million records breached. Yet the FTC has filed only 55 total data security-related complaints, averaging around 5 complaints a year since 2008. Instead of attempting to resolve all of the data breaches, the FTC typically pursues only what it considers to be the most egregious data security practices. The FTC has used a reasonableness standard to determine what constitutes an unfair, deceptive data security practice. What constitutes reasonableness is determined virtually entirely by industry standard practices and is contingent upon the sensitivity and volume of data, the size and complexity of a company, and the cost of improving security and reducing vulnerabilities. This deference to industry keeps the FTC from creating arbitrary and inconsistent data rules. The FTC does not pull rules out of thin air. Rather, it looks to the data security field and industry to determine fair and reasonable practices. Virtually all data security regulatory regimes which use a reasonableness approach, of which there are many, not just the FTC, have 4 central requirements in common: identification of assets and risks, data minimization procedures, administrative, technical, and physical safeguards, and data breach response plans. The details of these requirements are filled in by industry frameworks, accessible resources online, and a vast network of privacy professionals and technologists dedicated to helping companies of all sizes understand their data protection obligations. Of course, there's always room for improvement with any regulatory agency, but diminishing FTC power will probably not ultimately make the climate easier for business. In fact, given the vital importance of data protection in commerce, a reduction in FTC authority would likely result in the passage of more restrictive and possibly conflicting state laws regarding data security, more actions by state attorneys general, more lawsuits from private litigants, and more clashes with the European Union over the legitimacy of U.S. privacy law. In the long run, a weakened FTC would likely result in a more complicated and less industry-friendly regulatory environment. Data protection is a complex and dynamic area for consumers, companies, and regulators. Section 5 enables the FTC to be adaptive and serve as a stabilizing force for consumers and companies. Thank you very much.
Thank you. I'll now recognize myself for a round of questioning. Mr. Doherty, there was an allegation by Taversa that there was a data breach. Have you seen ever any indication, collateral indication, that that breach went to third parties and resulted in any use of the identity information? Any?
Thank you, Chairman Issa. As a matter of fact, no, sir, we have not.
Okay. Mr. Roessler, same thing. You put up with years of lawsuit. Did any of the complainants have any demonstrated information that their identifiable information had actually gone somewhere, or just that there was a vulnerability?
To my knowledge, there is none.
Now, if there was a breach, meaning it was taken, you had, what was it, 184 records that were alleged? Mr. Doherty, you had thousands?
Correct, 9,000.
I've heard an expression that I'd like to see if you all agree with. If you have thousands of records, whether it's 184 in your case or many, many thousands, if they've actually gone out to third parties somewhere, they've, in other words, mined them, doesn't it defy gravity that none of them have led to any use of that information in either of your cases?
Yes, Chairman, I said I would agree with that.
Okay, so I'm not a student of statistics, but I had to take it in college. I certainly agree. So the allegation that you're facing is that you had a vulnerability, not an actual breach in reality, because a breach would demonstrate some use. What they really said was, Mr. Roessler, you didn't protect your site. You didn't have a good enough lock on your site. Is that correct?
I believe so, yes.
Mr. Doherty, same thing. Your lock wasn't good enough.
That's correct, sir.
Now, the American people may not understand cybersecurity at this point, but they understand the padlock on their front door, their garage door opener. And I just want to put it in perspective for a moment. 90% of the garage door openers made before the year 2000, a product that simply takes the chip and sequentially goes through the combinations will open every one of those garage doors. Before 2000, the vast majority of garage doors simply you had to go through anywhere from 250 to a few thousand combinations, and eventually your garage door would open. People haven't gone back and changed their garage doors. Unless you have a Medico key or a number of other very high security keys, if you have a typical key, it can be picked by any locksmith. So are these people leaving a vulnerability? Maybe yes, maybe no. But I want to put in perspective for both of you. The allegation, as I understand it from previous testimony for this committee, is effectively one of your employees may have installed a program that was sort of the equivalent of putting a little bit of bubble gum in the door latch so that the door didn't really lock and there was a vulnerability. In both cases, as far as I understand, there was no allegation that you instructed the employee to do it or that you did it or that it was done with your knowledge. And Mr. Roessler, and I understand in your case you never found the alleged peer-to-peer. Is that correct?
That's correct. And I don't know that the allegations were ever about an employee, simply that a file that Open Door had created had gotten out.
Right. But a file that was never found except in the hands of Traversa.
The same. And as a matter of fact, if you look at the FTC's press release announcing their litigation, they never use the word breach. That's correct, sir.
So we're not talking about a loss of data. We're talking about the vulnerability, the same vulnerability that every time a notebook like this or a computer notebook walks out of a government office with personal information on it, like it did in the case of the famous VA one, where somebody simply left their notebook and 1 million veterans' identifiable information was there. It's a vulnerability. If it actually occurs, it occurs because of a human failure in most cases, not because of an inherent system failure. Mr. Doherty, you were running a .com. Did you have professional advice and counsel, and did you buy software to protect against this type of thing?
Well, yeah, we ran a medical laboratory, and that was.
But I mean, you had an online presence, which
we had an online presence.
Mr. Roessler, same thing. You from what your testimony, you engaged professional outside people to give you security.
That's correct.
So you used what you would consider and still consider to be maybe not best practices, but the best practices you knew of and could afford, right?
Yeah.
We were told under oath by Mr. Bobek twice that, in fact, deceptive software was what they went out looking for and found these breaches. And I just want to close by asking just one question. Mr. Roessler, and I keep mispronouncing, is it
Roessler?
Roessler. Mr. Roessler, in your case, you had a kind of a unique thing that I want to make sure you get a chance to explain to us. A company, Traversa, in Pittsburgh, more or less, contacts you. Coincidentally, a plaintiff's law firm in Pittsburgh, Pennsylvania, as I understand it, forms a class action lawsuit and goes after you and has the information to contact those very people who they told you you had this breach. So the law firm has the name of all your clients. Is that right?
That's exactly right.
And they didn't get it from you. So in your case, you do have a breach. You know that somebody clandestinely got your clients, your AIDS patients' information, gave it to a law firm who then used it, and I'd ask unanimous consent that the sample, and we'll get it here in a second, letter that that law firm sent out to every one of your patients This is called Serrano and Associates. And it says right on the bottom, this is a solicitation to provide legal services. And is this a copy for the ranking member? I'll give a copy to the ranking member. You've seen that solicitation.
Indeed.
So I just want to make sure for the record that both sides understand. Traversa contacts you and says there's been a vulnerability, offers you to sell you the services for nearly $500 an hour. You turn them down after talking to your professionals, find no vulnerability. But then a law firm has the very information they were talking about, which obviously was gleaned somewhere and probably off of your servers or your drives. They then, it gets somehow to a law firm coincidentally in Pittsburgh, who then goes about creating a class action suit, contacts your patients who in no other way were contacted except by this law firm, and proceeds to sue you for years.
That is my perspective.
Okay. I now recognize the ranking member.
Mr. Chairman, to indulgence, before I ask my questions, I'll ask for just 1 minute to clarify a point for the record with unanimous consent with regard to some statements you made in your opening statement. May I? Thank you very much. Mr. Chairman made some points in his opening statement about the potential immunity for a witness. And I take this moment because, Mr. Chairman, everybody on both sides of the aisle care tremendously about whistleblowers. There's not one person on this, Republican or Democrat, and our record has shown that. You said that the Democrats have been unwilling to consider immunity. That's not accurate. We have said consistently and repeatedly that we are willing to consider immunity. We participated in the proffer. We reviewed the video as well as many documents. At this stage, the committee has not identified evidence that would substantiate or corroborate the allegations of this witness against other individuals. The Chairman also said that we have sought out negative information about this witness in an effort to discredit him. That's not true. The information came to us from the CEO of Traversa's attorney about criminal activity. Once we found out about that, we wanted to know more about him. I mean, that's just logical.
I thank the ranking member, and I would say that this is perhaps outside the scope of this hearing. I would also note
but you just made these allegations against us. It's in the scope of the hearing because you put it in here.
You asked unanimous consent. I granted it. The fact is that my opinion in the opening statement will stand. I will say, for the record, since you just said it too, the fact is your committee members have refused, even sitting here in the House of Representatives, even inside a building with total security, they have refused to meet with the whistleblower, claiming that based on the allegations of Mr. Bobeck and his attorney, that they're too afraid to, men and women. So quite frankly, you can have your opinion. You can have your opinion, Mr. Ranking Member. I will have mine.
Very well.
But I've invited to.
I'll continue my 5 minutes.
Well, I'll start your 5 minutes over in a moment.
Okay.
I have invited in my opening statement, and indulgence of the witnesses, all members to look at the video proffer and all members of this committee to have access directly to the whistleblower for purposes of continuing the proffer. I made it clear in my opening statement, and I will reiterate it because I think the ranking member's point is good. Serious allegations about the personal life of the witness have come forward. But again, as I said in my opening statement, allegations do not go to the direct claims of the whistleblower as to the facts that he said in his proffer had occurred. So is the whistleblower claiming he did no wrong? Just the opposite. The whistleblower has come forward with a proffer because, in fact, if he makes that testimony, he will do so at the risk of prosecution. The whistleblower has already taken the fifth in another venue and, as a result, qualifies for the question. Now, in the Lois Lerner case, Mr. Cummings, we had a witness who you kept saying you wanted immunity for, but she only said she was innocent. In this case, we have an individual.
There you go again.
This individual came forward and said wrongdoing occurred. It has led to today's hearing. And I simply, in my opening, asked all members to take the time to look at the information individually, because I do believe that to get a full understanding and cross-dialogue, because everything that is pointed out by a whistleblower is subject to, in fact, credibility check as to the facts brought. But that dialogue will not be possible unless the whistleblower is granted the limited immunity as to exactly what and only what he came forward with as allegations against Traversa, and as a result, the FTC and perhaps false statements made before this committee. It is a serious claim. I take it seriously, and I ask all members to individually look at it. Mr. Cummings, most members have never seen any of it, and that's why I was making it available today in open hearing to look at it and make their own decisions. And I thank the gentleman. Please restore the entire 5 minutes.
We had sought out negative information about this witness in an effort to discredit him. That is not true. The witness has engaged in numerous criminal activities that go to credibility, and he failed to disclose to the committee during his proffer. He failed to disclose them. And some of these activities were occurring at the same time that we were speaking with that he was speaking with the committee. Generally, I believe the committee should grant immunity to witnesses who have admitted to engaging in criminal conduct only in rare circumstances when those witnesses provide concrete evidence of criminal activity by others. I appreciate the goal of rewarding whistleblowers who come forward voluntarily to identify waste, fraud, and abuse, and we have a record of that. But I do not believe in immunity. Immunity is a proper reward when individuals provide evidence relating only to their own wrongdoing. Although we remain open, and I want to be clear, although we remain open to considering immunity, should additional evidence emerge, we cannot responsibly support immunity at this time. Now, according to the Republican memo for today's hearing, one of the main topics is, and I quote, whether the FTC has the authority to pursue data security enforcement actions under its current Section 5 authority. So let's ask our witnesses. Mr. Steinmeier, you have written extensively on this topic. In one article, you wrote, and I quote, "The agency is the Federal Government's largest consumer protection agency. The Commission routinely investigates publicly reported data-related incidents with the threat of subsequent litigation. Since 2000, the FTC has brought 42 data security cases." End of quote. Mr. Steinmeier, with respect to the hearing in question today, I take it from your writings that you agree that the FTC has the authority to bring enforcement actions under Section 5 to protect the data security of the consumers. Is that right? I can't hear you.
Mr. Cummings, thank you. That is actually a really great question, and I appreciate the way that you presented it. At the outset, let me just note that I come before the committee today with the understanding that the committee sought my expertise and understanding specifically about fair notice and due process concerns. Whether or not the agency has jurisdiction is actually, ironically, something that Congress has given the agency incredible deference to determine in and on its own, and it's actually subject to a number of pending lawsuits and litigation. So the answer to your question, I think, is that the agency absolutely believes that it has such jurisdiction, but that answer to that question hasn't been definitively resolved. And historically, under case law, the agency would receive such deference. But my focus is more on whether or not people who are going to be subject to that deference, whatever the ultimate outcome may be, have fair notice about what the law requires of them.
Mr. Herzog, you have also written extensively on the FTC's work on data security. So let me ask your expert opinion. Does the FTC have the authority to bring data security actions under Section 5? And one of the things that we should all be concerned about is chilling effect. And I just wanted you to respond to that.
Sure. I think that, yes, the FTC does have the authority under Section 5 to regulate data security practices. If you look at the plain wording of Section 5, it's intentionally quite broad. There are limitations, so there are limits as to what constitutes an unfair practice and a deceptive trade practice. But certainly, given the the heft of both the opinion, the recent opinion in the Wyndham decision, and the FTC's practice generally in the way that we interpret statutes, the FTC has the authority to regulate data security. With respect to chilling effects, I think that the FTC has proceeded in a pretty judicious and conservative manner with respect to the regulation of data security. And so it's not like there's been a dramatic lurch forward. As a matter of fact, they've been inching along through several different presidential administrations, basically along the exact same course with no appreciable difference. And so I think that the body of jurisprudence is actually sound in that regard.
Professor, can you describe why it's important for the FTC to exercise its authority over data security breaches?
Sure. There are several reasons. One is it gives the U.S. system of data protection legitimacy and heft. So many, for example, international agreements like the EU-U.S. Safe Harbor Agreement is contingent upon the FTC being able to regulate data security, particularly now that there are questions about the strength of U.S. data protection program. Also, the U.S. system of regulating privacy is done in a patchwork manner, so there's no one great law that regulates data security across the United States. And what that does is it leaves a number of different gaps, and the only statutes that really, the only avenue by which we can provide a baseline of data protection in the United States right now is Section 5 of the FTC Act. And so Section 5 helps harmonize a lot of data security practices, and it also has been consistent with a lot of other data security regulatory regimes.
You heard the testimony of Mr. Daugherty and Mr. Rossler, and by the way, gentlemen, I'm sorry that you've gone through what you've gone through. I spent my life representing people who were not properly, they were improperly accused. But you heard their testimony. I was just wondering, do you have a reaction to that? It seems as if there's a question, and Mr. Steinmeier talked about this a bit, as to charging folks. The way that folks are charged, they use data that, I think, Mr. Steinmeier, you would agree with this, based upon what you just said, that you consider unfair charging. Would that be a fair statement?
I'm not sure I understood precisely the question, sir.
But you understand what I'm saying, right, Mr. Hudson?
So I think that the allegations that have been brought up are that there's not enough notice given to companies and that they're expected to follow rules that they say they don't know what they are. The answer that I would give to that is that the FTC uses a reasonableness test, and a reasonableness test for regulating data security is the most common way, if you look across regulatory regimes, to regulate data security. So the Gramm-Leach-Bliley Act and HIPAA and many state regimes, all of them use a reasonableness test. And the way that you execute a reasonableness test is you defer to some other existing body of standards, right? And so in this case, it's a complete deference to industry standards. The FTC actually doesn't create the standard at all. Rather, they say, what is industry doing? And there's a whole body of study. So there are whole industries and fields of study dedicated to what makes not just cutting-edge data security, but just industry standard data security and best practices. And that's what the FTC says you should look to determine what the baseline is. And so the FTC actually isn't unique in its regulatory approach. There are states and other statutory schemes that utilize very similar approaches.
Thank you very much.
Can you explain to me then why that HIPAA and HHS has not come after LabMD?
I'm sorry?
Can you please explain then, if you're talking about industry standards, we're a medical facility, we're under HHS and HIPAA, they have not come after LabMD or cited anything.
Well, I actually can't speculate as to why. There are lots of different reasons why claims are brought or not brought.
It's a good question, but we probably won't have any more between witnesses, if you don't mind. But I do want to clarify just two things very, very quickly. You said a body of jurisprudence. That would imply that there's been decisions at the district and then the appellate court. Are there any?
Well, we do have a decision at the district court level in the Wyndham case, but actually jurisprudence can come from a number of different sources, and primarily in the case of the FTC, it comes from the complaints that they filed.
Okay, so the consent decrees are a body of jurisprudence where they sue and settle and you're calling that a body of jurisprudence. I just want to make sure that's
Well,
what you're
not the
talking
consent decrees, but rather the complaints that indicate what the FTC considers to be an unfair,
okay.
deceptive trade practice.
And I'm only one more quick one for Mr. Doherty and Mr. Roessler. Were you given any safe haven or guidance by the FTC as to how you could, in fact, not fall under unfair practices at any time from the beginning until today? Those so-called standards that Mr. Hartzog has said exist.
Well, sir, thank you for that question, Chairman. I said no. As a matter of fact, I stated and is further indicated in my written testimony, quite to the contrary. In briefs and in quotations from the FTC, they argue they don't need to promulgate rules or informative standards. And even their experts said that we should Google them. And this is just not a way to regulate an American industry and economy, let alone the world of medicine.
My response would be that the communication that Open Door received from the FTC was one simple letter. It was a warning that we received from them. There was no other communication, and during that time, it was simply about a file being out, and they listed the file.
So they just didn't pursue you, nor did they give you guidance on how to remedy.
That's
And
my understanding.
did you have someone else you want to follow up on?
Just to follow up on, the Chairman's question. Mr. Herzog, you just heard what they said. You talked about a body of jurisprudence. And here you have folks who are saying they had no idea what was going on. Can you react to that? Is that a fair statement, gentlemen? You didn't.
I would actually say that it's not a fair statement, nor is the FTC unique in requiring, a standard to which there is not, to the utmost specificity, right? So, for example, in tort law, you're expected to build products safely, but there's not a manual that you get when you start designing products that say, here are the 130 steps that you can take to make a product safe, right? You actually look to industry standards, which is another thing that is relatively common, and that's kind of evidence that is used to determine whether you're acting reasonably or not.
Thank you very much, Mr. Chairman.
I think all of you, I will tell you, as somebody who set industry standards, sat as a chairman of a trade association, I understand that safe havens are critical. Industry standards, if you live up to them, you're supposed to get a level of immunity, at least from persecution by your government. It doesn't seem like that exists here. Mr. Mica.
Thank you, Mr. Chairman. And Mr. Doherty, you had LabMed.
LabMD, sir.
LabMD, and you had Open Door, Mr. Roessler.
That's correct.
Two different activities. Now, were you first notified by FTC that there was some breach or some problem with your handling of data, Mr. Doherty? Were you first when did FTC notify you first?
They sent us an 11-page letter and starting the inquiry. There was
before that, no.
No, sir. We're just under HIPAA.
Before that, no, with you. Just trying to look at what took place here. So you both are conducting your business or activities, and you both get calls from this firm, Traversa. And that was the first notice that you had from anyone that you had problems as far as data security. Is that correct, Mr. Dodd?
And I would only ask one thing, that whenever you answer, make sure it's verbal. The clerk's not allowed to write down head nods.
Don't count. So, Mr. Doherty, when you first, I want to find out when you first found out from some outside source that there was some breach.
The outside sourcer was, the first one was Traversa in May 2008. And then
Mr. Roessler?
For Open Door, it was also Traversa that notified us first.
And that firm told you that they had, I guess, been fishing or surfing, whatever the hell they did, and that they then did they offer to help remedy your situation, Mr. Doherty?
Well, yes, sir. They would not.
What was the offer?
The offer was
how much an hour?
$475 an hour with a $40 minimum, no guarantees.
Roessler?
It was $475 an hour.
And Mr. Doherty, what did you tell them?
I told them I was not interested until they gave more information.
Okay. And Mr. Roessler, what did you tell them?
I didn't respond.
You didn't respond. Okay. So after your initial contacts, your first contact of the breach, but then you were later notified by FTC that there was a problem?
Well,
Mr. Doherty?
we were called by
It was subsequent.
later in 2009 or 2008. We were told by Tyversha they were giving it the Federal Trade Commission, and then Federal Trade Commission contacted us 14 months later.
And Mr. Rossler?
Yes, afterwards.
So, we tend to believe that FTC was informed or got that information from that company. Would you assume the same thing, Mr. Doherty?
Yes, sir, I would.
What would you assume, Mr. Rossler? You gave it to them. You called them up and said, we're doing this, and you ought to investigate us?
Excuse me?
That was a joke.
All right. Thank you. I don't know. I don't know the answer to that question, if that's how
But
that's
somehow
documented.
they got
That's
the
correct.
data. Well, to me, it looks like a little bit of an extortion game from a company trying to make a few bucks off of you guys fishing and then coming after you. That's just my assumption. Now, we don't have FTC and others in here. We'll have to find out more of what took place. Part of this is that, FTC was set up for a good and noble purpose, and that's to deal with deceptive and unfair trade practices. And we should have the right to have whistleblowers give them information. But a lot of the discussions also went around the standards and what's fair. But the standards do not exist specifically, Mr. Hartzog, as part of the testimony. That's first. And then secondly, you made a good point that we don't want to clip FTC's wings to inhibit their power to go after bad actors. Is that correct?
Yes, that's correct.
So, but if we find out, again, that the motivation for this was their non-participation in the scheme, it doesn't seem like they were treated fairly, one, and two, that you two were never given notice to correct the practice. Were you given notice to correct what they considered?
Oh, we were just given endless questions for years and then a suit. No, that was all we were given.
Were you given
In our letter,
a remedial course? Or
in our letter, it was suggested that we,
cease and desist?
something like that.
Remedy your situation?
That's right, look into it.
Because I think, again, businesses need to be notified by the regulatory agencies if there is a practice, and then if they don't clean their act up. You didn't devise those software systems, probably something you purchased that had a...
LimeWire was never even purchased. That's just malware that was out there that was put in by an employee with a total lack of authorization.
But it wasn't a purposeful thing, and when you found out, you tried to remedy it.
Absolutely, sir.
Mr. Rossler?
We never had any evidence of having
But
any,
when you found out, did you try to remedy it, the situation?
we just researched to find that we had no risk of that. That
Okay.
was-
All right, I yield back.
Okay, thank you. Mr. Hartzog, just to make sure, was LimeWire ever gone after by the FTC for their deceptive practices of creating the vulnerabilities? You looked through the body of jurisprudence.
I do not believe so. So
So
I
they
don't
never
know
went
whether-
after the people who created the vulnerability, just people who were victims?
I don't, I'm not privy to investigations. I only know about the filed complaints, but as far as I know, there was no filed complaint against LimeWire.
Yeah, well,
Thank you.
makes sense. They were probably without deep pockets and too slippery. The gentleman from Massachusetts, Mr. Tierney.
Thank you. Mr. Hartzog, apparently there was ultimately an agreement or a decision that the companies that are testifying here today did not live up to industry standards or some other measure of reasonableness. Is that fair to say?
Yes, that's fair.
So in that determination by the FTC of whether or not they complied with the reasonableness on that, is the sophistication of the company, the size of the company, the resources the company might have for establishing secure IT, the danger of the release of their thing, are all of those factors in that determination of reasonableness?
Absolutely. That's one of the reasons why a one-size-fits-all checklist for data security will never work, because it's far too dependent upon variables like that. And so of course, large companies, large tech companies that Microsoft and Amazon and all of these others are expected to have significantly different and probably more robust data security practices than, say, smaller businesses. Now, of course, there's a baseline for everyone collecting personal information, but it varies wildly as to what is constituted in any given circumstance.
So is there an FTC process where when they become notified that a problem may exist, they notify the individual and give them an opportunity to cure?
Because I am not privy to a lot of the internal investigations within the FTC, I'm unable to answer that right
Mr. Stegmeyer, do you have any information on that, whether or not the FTC, as a matter of course, when they have an allegation or a concern that somebody may not be being reasonable in securing their IT, they give that company an opportunity to cure before they take action?
I've never had an experience in 13 years of doing this where they proffer the opportunity to cure in the manner that I think you're suggesting. I've had a number of non-public resolutions many times, but I haven't had this sort of, I think, in the Chairman's words, safe harbor situation where they say, we've brought this to your attention. We see that you've taken corrective measures, and we've determined that that, is in fact good enough. In fact, it's their practice and part of Mr. Hartzog's analysis that the agency doesn't typically issue what would be referred to as a closing letter for investigations. But in my private, personal capacity appearing before the agency representing clients, the characterization you described is not consistent with my experience.
Are either Mr. Herzog, Mr. Stegmeyer familiar with a situation where their clients were notified, as Mr. Rossler was, that you apparently have a problem, and then no further action was taken because your client did something about it?
So it hasn't been my experience that the agency is typically calling to the attention of individual companies, incidents, or situations, but rather they come investigation in hand with an investigatory posture, try and figure out what happened, rather than more a notice and corrective posture. But to be clear, I am aware of numerous cases where the agency has chosen not to continue investigating.
Okay. Is that similar to your information, Mr. Hartzog?
That's correct, based on my information.
Thank you. Mr. Rossler, you received a letter from the FTC notifying you that they believed you had an issue and suggesting that you do something about it.
That's correct.
Right. And what you did about it, you said, was you went and rechecked again to see if your people could find anything on the peer-to-peer. Is that right?
What I said was that our IT subcontractor looked at our network to see if there was any P2P software within our network or on any of our computer laptops, any workstations.
Did you at all do any research or ask your legal counsel, your IT subcontractor, to do some research about what the best practices in your industry were and whether or not you were in fact complying with those?
Indeed, we did.
And what was the result of that?
The result was that we were meeting those standards, our network was secure, and that we were compliant.
And did the FTC ever take any follow-up action against you?
None that I am aware of.
Thank you. Mr. Stegmeyer and Mr. Hartzog, again, your help, if you would. When a determination is made by the FTC that there's noncompliance or there's an unfair or deceptive practice, are the penalties automatic, set at a certain amount once they're found, or is there discretion for the FTC to take into consideration mitigating factors?
So the agency doesn't actually have statutory penalty authority. They enter into a consent decree, which typically doesn't have a monetary penalty or remedy. As to the factors that they use in terms of how they decide which cases to prosecute or which cases not to prosecute, I would respectfully disagree with Mr. Hartzog in the sense that, having done this for a long time, the precise motivations and contours of what constitutes reasonable behavior and reasonable information security behavior from the perspective of the agency that's authoritative is no more clear to me today than it was 13 years ago.
I'm going to let you guys fight that out offline here on that. But so if there's not a monetary penalty, what is the nature of the action that the FTC takes ultimately?
I think one way to think about it is to have a new board member who helps supervise your privacy and data security process for the next 20 years, including typically biennial privacy and data security audits through an approved third-party contractor who essentially will audit and review your processes and report to the agency Additionally, they have a tool which they call, is commonly referred to as fencing in relief, through which once you're under an order, you are subject to financial penalties if you should violate the order. And in my experience, it's not uncommon for companies to spend as much as $500,000 a year or more simply to undertake to comply with the underlying orders. So I would respectfully disagree with Mr. Hartzog to the extent that it takes into account the nature and size of the underlying companies. In fact, my experience has been the opposite, that the size of the company doesn't dictate what level of security the agency seems to believe is required in a number of instances.
And I assume that
The gentleman's time has expired.
ask unanimous consent for one further question.
As long as it doesn't take another minute and a half extra, go ahead.
I'll do my best. And the cost of this sort of outside entity or auditor that you're talking about is borne by whom?
Entirely by the company, sir.
Thank you. Thank you.
Thank you. Mr. Walberg.
Thank you, Mr. Chairman, and thanks to the witnesses for being here. Mr. Stegmeyer, if you could just further help me to understand what are the FTC standards for determining whether or not a company's data security practices violate Section 5?
Thank you very much, sir. A couple of things. The articulated standard is one of reasonableness, and that is the extent of the standard. I note that for the folks that are here today, and I think this is important for the committee to understand, I think that we learned from Mr. Rossler and Mr. Doherty that they were initially begun the investigation in 2008. It wasn't until 2011 that the Federal Trade Commission issued a best practices guide identifying a number of recommendations that it thinks are required for reasonable security. But to answer your question, I think, more directly, the troubling thing about that guide and the thing that's been difficult for many companies is if you ask me to identify which, if any, of those items that they identify as best practices are legally required, I could not tell you.
So this is an evolving notion, as it were.
Absolutely, and I think the agency itself has taken that position repeatedly. The agency takes the position that it needs flexibility because technology is changing, what we think is privacy is changing, data security is changing.
Well, what then gives the FTC the authority to take enforcement on these evolving actions, especially in what's considered reasonable?
Sure. So as Mr. Hartzog identified, the language of Section 5 is incredibly broad, and courts have generally given deference under what's known as the Chevron case to agencies to determine their own jurisdiction. So unless that exercise of jurisdiction is arbitrary or capricious, for the most part, absent Congress stepping in, the agency's determination, will prevail unless or if a court disagrees. And as I mentioned to the Chairman earlier, there are a number of cases pending that challenge exactly this question.
Mr. Hartzog, do you agree or disagree that the FTC should be taking the lead in establishing new regulations governing data security practices?
Well, I think that the FTC certainly plays the pivotal role and should play the pivotal role in establishing data security regulation in the United States, but I do think that it's wise for the FTC to continue to defer to industry standards rather than try to make up their own standards, but rather follow what industry has determined is reasonable and appropriate data security, because I think that that kind of deference keeps the FTC from acting in an arbitrary or inconsistent way.
So in other words, kind of a shared partnership lead.
That's right. So it's a co-regulatory regime, right, where you let industry say this is what is reasonable in our field, and then the FTC then looks to that to determine which companies have gone beyond the boundaries of reasonableness.
Mr. Stegmeyer, can a business owner look up the rules for data security to make sure a business is in compliance?
So if you're subject to the Health Insurance Portability and Accountability Act, you can. In fact, the HHS has issued privacy and data security regulations. The Federal Trade Commission has not. If you are a financial institution subject to the Gramm-Leach-Bliley Act, there's been notice and comment rulemaking. You can look up those regulations. But again, if you're subject to the FTC's jurisdiction, you cannot.
A pattern is emerging. Mr. Doherty, did you know where to look up the rules or informal policies that governed FTC data security practices before you were contacted by FTC?
No, sir. Because there were none. I mean, we've had professionals in and out. We had SANS and STU people in. No one said anything about them. We were fully within the medical community.
How easy or difficult is it to keep up with these informal policies?
Well, I think it's nearly impossible. I mean, because they don't tell you till after the fact. Whereas in HHS, in the world that we reside, in a regulatory world, it's quite simple. But in the world of medicine, which you're trying to get into, they're not using that format.
And finally, Mr. Doherty, in your opinion, is it fair for the FTC to expect businesses like yours to be able to locate and follow data security practices?
Oh, we're all for following data security practices, absolutely, but we need to obviously have them take a leadership role and not a reactionary role. As much as they want to say how broad this needs to be, breadth does not mean infinity, and there has to be some boundaries. And they seem to continually argue, well, we have broad scope, we need broad scope, but that doesn't mean they don't have to say anything. I mean, we all have laws. That doesn't mean we call it a crime when we see it. So I think they need to be more reasonable in their boundaries and their communications, especially when they choose to get into medicine. That is really an alarming overreach.
Sounds reasonable. Thank you. My time has expired.
The Chair recognizes the gentleman from Massachusetts, Mr. Lynch.
Thank you, Mr. Chairman. Now, this dispute is currently in the FTC Administrative Court. Is that correct?
Is this to me?
Yeah, anybody.
Okay, yes, sir. Against LabMD, yes, it's an administrative court, sir.
It seems to me it's a good place for it. I don't understand how this matter. There are a lot of administrative disputes that one side or the other feels offended by. It just surprises me that you're before Congress, given the small amount of work we do anyway, and now we're engaging in this. I don't think this whole dispute, this whole hearing, is appropriately before us. Let me just get that out of the way. Earlier, Mr. Herzog and Mr. Stegmeyer, we heard the chairman say that, and get confirmation from two of the witnesses, that there is no breach unless someone uses the information that's been put out there. In other words, you can have a door that's unlocked, I guess is the analogy that was used, and that even though information was not kept secure, there's no breach until somebody actually uses that information that's been put out there. Is that the state of the law?
So whether or not a security breach exists is actually a term of art, as the members of the committee may be aware. I think at least 47 states have breach notification laws using differing standards or requirements. So I think we'd have to think about sort of a particular—
Well, let me ask you, any of those states say that the information has to be used before a breach is declared?
They tend to use the operative phrases acquired or accessed without authorization.
Okay. So just putting information out on the Internet, if nobody's using it, there's no breach.
It's an active matter of dispute as to whether the mere accessibility of information constitutes a security breach, and a lot of really smart people would disagree very vigorously.
Yeah, so you can put stuff out on the Internet, secure information on the Internet, and that wouldn't be a breach, Mr. Stegmeyer.
That's not what I'm saying at all. What I'm saying is smart people would disagree, and they frequently and regularly do. But I think an important consideration is under HIPAA, for example, whether you adhere to the security rule, in other words, whether your systems are in fact secure, is different than whether or not you've had a breach. So under HIPAA,
well, I'm just asking you here whether it's required in order to be guilty of a security breach, whether someone has to use the information. That's what I'm asking you. Mr. Herzog, you want to take a shot at this?
Sure. The mere fact of a breach itself actually isn't a violation of any particular law, right? So there are a couple of points. One is that Section 5 defining an unfair trade practice as one that either causes harm or is likely to cause harm, right?
Okay.
So you actually don't have to have any kind of breach or misuse in the first place. The second point is the only harm that can come isn't necessarily one of, like, say, use or ID theft, right? So mere exposure can constitute it. And then the third thing to remember is that the wrongful actions here aren't that a breach occurred, right? A breach is really perhaps just a symptom of the problem, which is a failure to have good data security practices. So regardless of whether the breach happened, whether it didn't happen, whether information was available or whether it wasn't available, all of that only really goes towards showing whether there were good, reasonable data security practices or not, and that's really what we're looking for.
Right. That's the preventative aspect of this.
Right, right.
If we had to wait till your Social Security was used by someone that you know, then
Correct. Well,
we would have to sit on our hands until somebody was abused, you know, somebody's information was acquired, and
which is very difficult to show. And it's important to remember that data security is a probabilities game, right? So, so what you want to, there's no such thing as perfect data.
Let me just jump to this quick. Mr. Rosal, your clinic serves patients that may have HIV or AIDS, is that right?
That's correct.
Did the master list ROSA file have personal information about clients of the Open Door Clinic?
It did.
And about how many Open Door clients were listed in the master list ROSA file, do you know?
About 150.
And the FTC wrote you that the clinic file master list ROSA was available to users on this peer-to-peer file sharing network, right?
They did.
So the information was out there. So are you saying that the FTC was wrong to contact you on that? Is that part of your complaint?
Not at all, no.
Okay. Where did the FTC has not filed an enforcement action against you for that, right?
That's correct.
So wherein lies the overreach on the part of the FTC?
I am not aware of overreach.
Okay. I'll yield back. Thank you.
The Chair recognizes the gentleman from Tennessee, Mr. Duncan.
Well, thank you, Mr. Chairman, and I appreciate Chairman Issa calling this hearing because what I've heard thus far is very disturbing to me. I was presiding over the House until a few minutes ago, and so I didn't, I'm sorry I didn't get to hear the testimony, but to see, if I understand this correctly, Mr. Dougherty, this Tyversa firm contacted you or your company and told you of possible problems and asked you to hire them at a rate of $475 an hour, and then when you declined to do so, they turned you into the FTC.
That's correct. That was all in 2008.
And then the FTC started pursuing you, taking action against you.
That's correct.
And I think I just was told that you're close to being out of business, or?
The laboratory operations closed in January of this year because we've been completely sideswiped by this.
And Mr. Is it Ressler or Rosler?
It's Rossler.
Rossler. Mr. Rossler, your story is very similar, is that correct? Except you're still in business.
I don't know that my story is similar. It's got its differences. Yes, we are still in business.
But you were contacted by Tyversa.
That's correct.
And for $475 an hour, they would take care of your problems. And then when you
also correct.
declined, they contacted the FTC.
That I'm not aware.
Well, according to the staff briefing we have, the FTC, this Tyversa company told on or reported or turned almost 100 companies into the FTC. And Mr. Hartzog, don't you think that in light of what's come out here today that the FTC should check on something like this if another private company turns in a company to see what conflict of interest is present? Because there certainly was a conflict of interest in these cases we're hearing about.
It's difficult for me to speculate on that without knowing the exact details, but it's my understanding that the FTC actually gets information about what constitutes, a potentially unfair, deceptive trade practice from lots of different sources, including public complaints in general, many of which might be valid and many of which might actually be invalid.
Well, I know they get from many sources, but when there's a obvious, seemingly almost criminal conflict of interest involved, it looks like the FTC would at least check that out, because that could easily be checked out on the front end of things.
Certainly the FTC should make sure that any allegation that's turned into them is actually valid. And so I think that, of course, it's incumbent upon them to make sure that the facts that are alleged to them are actually true.
Mr. Stegmeyer, do you think, you're a law professor, do you think anyone should be prosecuted criminally on things like this, what you've heard here today? If these facts are proven?
If the facts as alleged turn out to be true, no, I would not think that prosecution should necessarily be appropriate. But I think if I'm understanding your question more correctly, do I think it's appropriate for this committee in Congress to review the agency's behavior? I think it's incumbent on Congress to do so.
What do you think should be done in addition to this committee looking into it?
So I don't profess to be an expert on all of the remedies or different mechanisms. But one of the things that I think we've seen, and I think is critically relevant, is to create an environment where companies can understand what's actually expected of them as a matter of law, so that then when and if the agency should come to investigate them, there's much less of an element of surprise. And that's really sort of the crux, right? The Constitution protects us from being prosecuted when we couldn't possibly have known what the law is. And I think Mr. Daugherty could testify or would testify about his experience in that regard. And I think he has testified to the effect that he understood that he was subject to HHS's jurisdiction and being subject to the FTC's jurisdiction, and then what that meant in terms of what's actually required is as opaque today as it was in 2008 for him.
Well, the problem that many of us see now is that the Federal Government is prosecuting people for unintentional violations of the law, and that's not supposed to be criminal, but a zealous prosecutor can make it an innocent, unintentional violation of the law seem to be criminal, and that's a pretty dangerous thing. The government should be in the business of trying to help companies stay in business, not with the goal of trying to run people out of business unless they have definite proof of intentional efforts to defraud people. Thank you very much, Mr. Chairman.
Chair recognizes the gentleman from Virginia, Mr. Connolly.
Thank you, Mr. Chairman, and welcome to our panel, especially my constituent, Mr. Stegmeyer, who's obviously cogent, astute, perspicacious, very compelling testimony. And we're not surprised, coming from the 11th Congressional District of Virginia.
Thank you, sir.
Mr. Stegmeyer, I wanted to clarify something you testified to just now. What is the status of Mr. Daugherty's case before the FTC?
So I haven't been following the precise contours of the case, other than the existence of the administrative procedure is highly, highly unusual. I'm not aware of any other case that's actually used that procedure.
Mr. Daugherty, what is the status of your case?
The case is on pause until the immunity decision and proffer is worked out with this committee. And then the judge will make a decision from that point.
Okay. So it's still in adjudication? Pending?
Pending.
But there's been no verdict delivered?
No, correct.
Well, I will say I share some of more than some of the misgiving of my colleague from Massachusetts, Mr. Lynch, about the appropriateness of this committee even the perception of intervening in the midst of a regulatory adjudication for fear that, we start to set a precedent. So anybody, doesn't like a procedure can just come here and we'll have a hearing and judge it for ourselves. I just think that's a dangerous precedent if that indeed is what's going on. Mr. Stegmeyer, the title of this hearing is FTC Section 5 Authority, Prosecutor, Judge, and Jury. Do you view the FTC as playing a role as prosecutor, judge, and jury?
Absolutely. I think the structure of the administrative state, Section 5 being very broadly worded, with the agency getting deference to its own determinations about its jurisdiction, as well as its interpretations of the law being plausible, absolutely create a situation where it is difficult, if not impossible, to create due process remedies or ways for review that most regular people would think our system of justice entitles them to. And with respect, Mr. Connolly, to your comments about this particular proceeding, one of the things that strikes me is that with respect to the fair notice doctrine and due process generally, if not here, where else? And I think that really begs the question. In other words, Mr. Doherty, I'm not sure, has any other place that he could go unless and until this proceeding is resolved. So, again, maybe I'm a bit of, sort of a sentimentalist, but I think the due process concerns here are so significant that I would be, troubled to wonder where else one might go for redress.
That sounds good, Mr. Stegmeyer, but we cannot be substituting ourselves for regulatory agencies in the midst of their administrative procedures. The precedent that sets is very dangerous, in my opinion. And by the way, if there were thousands of them, there's no way you could raise the expectation that, no, this is where you come for redress if you don't like the process. Though I'm not disagreeing with you about the fact that there may be way too much authority, frankly, vested in this process, and that's a legislative issue, but not an adjudication. Mr. Hartzog, would you respond to what Mr. Stegmeyer said? Didn't he make a pretty good point there?
Sure. No, so I would actually disagree. I mean, I agree in the sense that this kind of title of judge, jury, and executioner is. The FTC is not unique among administrative agencies in that it has been given enforcement power and the power to kind of dictate rules. That's actually kind of administrative law generally, right? So to the extent that the FTC has the power to enforce the law and create rules through case-by-case adjudication, the FTC seems to be hardly unique in that respect. With respect to kind of fair notice due process.
Well, can I just interrupt you there? Mr. Doherty has a blog in which he refers to the FTC as lying, cheating, breaking every rule in the book, quote unquote. All professional tyrants and bullies have plenty of tricks up their sleeves. This nest, presumably the FTC, is no exception. So Mr. Doherty
Would the gentleman yield?
Of course.
I think many members on your side of the aisle have said the same about me on the dais. These allegations are not unique, are they?
Yeah, but I don't know if we all have blogs. But I mean, putting a charitable interpretation on what clearly is a source of anger and frustration for Mr. Doherty is a sense of, I'm not being treated fairly. This process is far beyond just a routine administrative process. It is one that is all-encompassing and all-powerful and capricious. My word, not his. So is this just like any other administrative process? Is there something unique or different about this one? I'm not referring to the particular case. I'm talking about the process. Because you just said, well, it's hardly unique. But if I read this blog and only rely on it for witness to the FTC process, I might conclude it most certainly is different and unique, or at least I hope it would be, if this is accurate.
Well, I can't comment as to the factual specifics.
I'm not asking you to.
Right. So without knowing the internal deliberations of what happened with respect to the FTC investigation with this particular case, I will say if you look at the complaint that was filed in this case, it is very consistent with all of the other FTC data security complaints. The FTC has been regulating data security since the late 1990s, and they've done so in a very conservative and incremental manner. The language that they employ is very consistent across every single complaint. The language that they use in their consent orders is very consistent. And so if you look at the complaint that was filed in this case, it does indeed look very similar to lots of other complaints filed by the FTC. And so in that regard, it would lead me to say that this is just another kind of incremental iteration on the FTC's data security regulation.
And just final point, if I may, Mr. Chairman, do you agree with Mr. Stegmeyer that, if not here, where, that this is a place to come for redress if you feel you're not getting it in the administrative law review, the administrative judicial process? Well,
I would just call note to the fact that everyone that is subjected to an FTC complaint has the right to judicial review. And so, that seems to be the structure that was put in place precisely to put a check on administrative agencies.
Would the gentleman yield?
Of course.
Just for a short colloquy, I think you made an assertion that perhaps this hearing and what you called intervening with the FTC was inappropriate. I just want to go through a couple of things very quickly for our benefit. Have you had a chance to look at any of the proffer material brought to the committee voluntarily by a whistleblower?
I'm not sure what the Chairman is referring to. I've looked at a lot of material.
No, there was a proffer brought. The committee staff has reviewed some of it. There was a whistleblower who came to us, unrelated. We did not initiate it, but rather a whistleblower came to us. And that in combination, and perhaps your staff can arrange, at the beginning I asked everyone to look at the proffer. It goes more than an hour. But additionally, the reason that this committee feels that, notwithstanding an ongoing, many-year ongoing FTC activity, that in fact, because Mr. Bobeck testified before this committee twice, while he was in fact turning people into the FTC for eventual prosecution, and because a whistleblower came to us, and because that whistleblower took the fifth at the asserted his Fifth Amendment rights at that proceeding, my understanding is the administrative law judge has, for the time being, held up with no prejudice whatsoever his proceeding as we continue to try to go forward. The judge is able to go forward with the case at any time, of course, but both this Chairman believes that we should hear the testimony of the whistleblower here, and I think the FTC would like to hear the testimony of that individual, because since he was a prior employee of Traversa, he is in fact likely to be a fact witness as to whether or not there is credible evidence against Mr. Doherty's company, which does, by the way, doesn't go to the FTC's authority that we are discussing here today. It really goes to the question of, is the FTC accurate in one or more of its pleadings? And for the gentleman's edification, it is our opinion that at a minimum, if the assertions that have been made are true, the FTC has been misled, and this committee has been misled on multiple occasions. The Secret Service, NCIS, the White House, through the assertion made, and I don't know if the gentleman was here when it was made, but the assertion that Marine One's cockpit upgrade was compromised and was in Iran may not have been true. All of those things cause this committee to think that we need to act now and to look into it. But I appreciate the gentleman's rightful statement that it's not for us to second-guess the FTC. Their administrative law judge has to make their own decision. We also, though, believe that we have an independent obligation based on the things I outlined, and I would hope the gentleman would agree.
Mr. Chairman, it might surprise you to hear that in some measure I do agree. However, I guess I'm raising the question, not for solution here, about what are the right boundaries for us, and when do we properly intervene because of our oversight function and duty. I was asked before this hearing, do we have a role to play in oversight of FTC? And my answer was absolutely. If there's something to be reformed or something certainly to be looked at, that is absolutely a proper function of this committee, and the idea that it's never proper is to be rejected. However, there are boundaries, and when there's a specific case in front of a judge, I am concerned that it not even be construed as a perception that we are attempting to tilt the judgment in a particular way, or to make ourselves the place of redress when people have a grievance, even though that grievance may very well be legitimate. Our role is not to hear the case all over again. It is to try to ameliorate the grievance if there are legitimate aspects to it that can be addressed legislatively. That's what I was raising.
And I think the gentleman and I would agree that we have to be very careful, both yesterday with the IRS and today with the FTC. But I do believe when somebody's testified before this committee multiple times, the assertions may be incorrect, and as a result, a series of suits already completed by the Federal Trade Commission with consent decrees might in fact have been flawed. And tangentially, Mr. Roessler, obviously we're concerned that a pattern of activity, business practices, you may have been a victim of and suffered, you and your insurance company suffered distraction and cost for years. So we are concerned with it, and that's why I was so appreciative of your being here today. This was a tough one for you to do. It's tough for you to tear yourself away and to take time out, but hopefully maybe a little bit like some hearings we've had over the years where people don't understand them at the beginning of it. If, in fact, they come to some of the assertions being true, then at the end of it all, people will say, yes, it was worthwhile. If, Mr. Connolly, if at the end of it all, whistleblower statements are wrong, assertions are wrong, and all of what we have been told is not true, and if, for example, that Pittsburgh event, the law firm was just a coincidence, if, in fact, both of these individuals had real breaches, then, in fact, if all those things be true, then, in fact, we went down a look-see that didn't end up. But today, I believe very strongly, and I think at least two of our witnesses feel strongly, that there's at least a credible case to look into it. And I might close, and I thank the gentleman for so much yielding. I remember when Pat Tillman's family was in front of this committee. I remember us looking at various events that were very controversial, assertions by grieving family members. This committee has taken the breadth of investigations by both sides' chairmen, and we've explored them. We explored steroids in baseball. We've done a number of things. The ranking member and I continue to work on trying to clean up the NFL's problem with human growth hormones. Those are not within the mainstream. So I do appreciate the gentleman, and I want to be very careful. I would ask, again, all members to look at the proffer, to meet with the whistleblower, even if he is never to be granted the opportunity to testify. The proffer itself might give you the reason for why we are going forward to try to find the facts through other means and why this hearing is here today.
The gentleman yield.
Of course.
First of all, Mr. Chairman, I was questioning, as I was listening to Mr. Connolly, whether this is in fact intervention. I'm not sure that it is, to be frank with you. But I'm hoping that at the end of the day that the FTC hears this. Clearly there's some things that need to be resolved here. And, I'm just, when I hear the stories of Mr. Doherty, Mr. Roessler, I think it concerns all of us if you have been treated unfairly, because we try to fight against that kind of thing. But again, I think, and I'm glad you said what you said about being careful, because it's interesting. In my office, Mr. Connolly, I tell my staff that if somebody walks in there and there's any kind of pending anything, judicial, quasi-judicial, I'm not touching it. I'm just not going to touch it because I don't want to interfere. Right. And I think it's probably a problem with it anyway, ethically. So, but hopefully this will lead to something where there's some clarification, Mr. Chairman, and so that we don't have these kind of situations, or if nothing else, at least some clarity comes to the people who are in the industry as to what is expected of them, what's fair, what's reasonable. And if we can come to that, and again, as I said a little bit earlier, Mr. Chairman, we have not said absolutely against immunity for a whistleblower. We just want to make sure that we dot our I's, all our I's, cross our T's. And so thank you very much. Thank you, Mr.
I thank the ranking member, and I thank Mr. Conley. We now go to the very patient, quasi-expert on HIPAA, Dr. Gosar.
Well, thank you, Chairman. I'm a dentist before I came to Congress, so I'm very aware of HIPAA and OSHA. And it's very different from what I'm understanding here, Mr. Doherty, right? I mean, we have classes, we have rules, regs. They're pretty astute and pretty well defined, right?
Yes, Congressman. As a matter of fact, we enjoy daily mailing offers for educational seminars that anyone could have at any day.
And so, like a typical small business, you update, you try to keep up of trends, making sure that you're up to par and protecting databases as well, true?
Correct. We always had an IT staff of at least 3 people, even when we were only like 15 employees, and we also had outside company help. And as a matter of fact, we upgraded to, we found in the small business community and in the medical community that's under 100 or 200 employees, there were no security products out there. So when the FTC approached us when we were trying to get an answer of what to do, and we couldn't get an answer, we went out to the industry, and they didn't have products for us. They only were with 500 company employees. So we had to find a company that would actually customize something for us that was built for that, for someone much bigger, that would actually work with us. We could only find 2 vendors to do it.
So I want to get back to this fair notice. It seems like if what I heard from Mr. Hartzog in regards to looking across the industry for fair and applicable application, they should have taken some of that into consideration.
Well, I would agree with that, sir, yes.
Yeah. Mr. Hartzog, are you real familiar with why the FTC is even in business today? Do you understand the history from 1978 to 1980? In fact, my Democratic colleagues almost actually shut them down during 1980. And underneath, in regards to the FTC only survived in its agreement to limit its discretion by issuing its now revered unfairness policy statement, true?
That's correct.
So there's even more onus. You bypassed it, but there's even more onus on the FTC to be fair and applicable across these applications. Would you agree?
Yes, there are.
Well, I mean, so the statute and the mission is very specific to the FTC, right? So the application across all agency boards are not exactly what you said.
Well, with respect to whether something constitutes an unfair trade practice or not, so it actually isn't even limited to deception, but the policy codification was to an unfair trade practice.
Well, my whole point is the FTC is further scrutinized by its jurisdiction in regards to that. So they have a bigger discipline by Congress, okay? Would you agree with that, Mr. Stegmeyer?
I think the agency has more of a track record historically, and speaking purely historically, of potentially running afoul and having congressional oversight. And for example, their rulemaking authority is highly constrained, coming out of some of the same things I believe you're talking about.
Yeah, so let me, I guess my question is that if we're coercing settlements, what good is the rule of law? How are we overseeing the FTC in a proper adjudication that they're already being scrutinized a little differently because of their past history?
I think it's a really good question, and I think it's one we need to explore further. Certainly, having represented companies that felt they were being coerced, I very much sympathize with the tone and tenor of your statement. And in the same breath, I would just say that my experience with the folks actually working at the agency has been of a really bright, hard-working, dedicated group of people that believe in what they're trying to do. And I think one of the things that can be happening here is a bit of disliking the messenger versus the message. And part of that is simply because we as a society haven't resolved what privacy and data security mean. but we have a law enforcement agency that's out there prosecuting companies with what it thinks it means, over more than a decade now. And that's really, I think, what brings us here is a tough spot, independent of anything that Mr. Doherty or the other information before the committee or the proffer, none of which I'm specifically familiar with.
And it seems to me that we haven't had oversight or reauthorization of the FTC, and maybe we need a mission. I mean, just because you're bright and you are affable in your job doesn't make you right in your application of the law, does it, Mr. Stegmeyer?
So I made a note to myself earlier, just because you do something doesn't mean you have the authority to do it. And so I would agree that a measure of oversight and review is appropriate, given, as the agency acknowledges, that technology is moving very rapidly, data is moving very rapidly, and clearly the agency has a very important role to play. But that is one that is, limited and subject to congressional review.
And so would you still agree that the review of you're innocent until proven guilty?
I would agree that you are absolutely innocent until proven guilty. I think that's the entire reason why I'm here today. And I think more importantly, it's really a shame if you're prosecuted and you couldn't possibly have known what the legal requirement was for which you are being prosecuted. And that's what the fair notice doctrine is about in the articles I've written.
Yeah. Mr. Hartzog, would you agree with that?
I agree with the general statement, but I would also say that the case-by-case way of establishing law is actually a part of it.
I mean, you didn't give a very good, notice about applicability across the board here. You tried to cite as a expert witness, and you tried to cite, which you really couldn't. And shouldn't that be more based upon predicated case law? So we should see, instead of coerced settlements, we see more applicability going towards the courts?
If I might, actually, if you...
The gentleman's time has expired, but you may answer.
Thank you. If you look at the complaints, actually, we actually see substantial overlap with the FTC complaints with the HIPAA security rule and Ground-Leach-Bliley. And so actually, it's actually a fairly nuanced standard. If you look at the complaints, which established in the case-by-case manner, really outline what an unfair deceptive trade practice is.
Thank you.
Thank you. We now go to the gentlelady from Illinois, Ms. Duckworth.
Thank you, Mr. Chairman. Thank you, Chairman, for being here today. I just want to establish some clarification on Mr. Rossler. I know you do tremendous work in support of our citizens who are suffering from AIDS and do everything that you can through your organization to support your clients. I just want to sort of go through the timeline of your particular instance. You were contacted by Traversa saying that they had these files that they had found on peer-to-peer networks and that for a certain amount of money they could help you with it. Subsequent to that, you then went to your IT providers and did a thorough search and determined that nothing in your networks had been breached. Is that correct?
That is correct.
And the file, at a later point in time, you received a letter from the FTC saying that there was this file on the Internet, and it was a different file name from the file that Traversa had informed you was out there. Is that correct?
That's also correct.
Great. Prior to this time, did you not suffer a break-in to your facilities where a laptop was physically stolen from your facility?
That's correct. In 2007, Open Door was the victim of theft of one of our laptops in our Aurora Clinic space.
Correct. And you did report that crime to the police?
That was reported, yes.
Yes. So when you got the notice from the FTC with the different file and going back and reviewing, is it true that you have determined that these files that were on the Internet were not a result of any type of a security breach to your network, but probably came from that laptop that was stolen?
That is an assumption that we do have, that the laptop that was stolen had these as well as other documents on that computer.
And so the FTC has not contacted you other than that first letter to say they found these files on the Internet. This is a warning. You need to deal with it. Is that correct?
That is correct. Thank you.
Okay. Do you have any evidence that the FTC turned over information of any of those files to any law firm that then initiated the class action lawsuit against you?
No evidence at all.
No evidence at all. So what I'm trying to get to here is the fact that there are two different things going on. There are the practices which I think appear to be very egregious on the part of Traversa, which I want to get to the bottom of. And then the fact that you were very much a victim of an actual theft to a facility that probably did have a lock on your front door, quite literally. And then the FTC finding a different file and on the internet from the one Traversa contacted you with and said, hey, this file is out there, take a look at it. You dealt with it. The only thing that I'm somewhat concerned with in terms of your actions is that you did not notify your clients for over a year whose names were on that stolen laptop. Is that correct?
That is correct.
But there now been that's a matter for state law. That's not under the jurisdiction of this committee here. But you've settled the lawsuit with this law firm, wherever they got the information from, not from the FTC, but from somewhere else. Your clients, many of whom are back with you and are happy with the treatment that they're getting?
That's correct. We are back to doing business as usual.
With what you love, which is taking care of your clients.
Very much. Thank you.
Thank you. Mr. Hartzog, could you give me your opinion on was it appropriate for the FTC to contact Mr. Roessler to say that, hey, we found a file on the internet that contains your client's names?
Sure, in the sense that the FTC has, a broad ability to look into lots of different data breaches to determine whether there was a reasonable data security or not.
Would the gentlelady yield just for a point of
I'll yield.
information? The committee can provide you with the produced written data that shows that Traversa provided that information to the FTC. So the source in both cases was Traversa, directly in contact, and then indirectly when the FTC gained from Traversa that same information that Open Door failed to, if you will, pay for protecting.
Thank you, Mr. Chairman. But I do think the FTC did contact Mr. Roessler with a different file name, which is how I believe you were able to come to the conclusion or the assumption, a working hypothesis, as it were, that it likely came from this laptop and not from a breach of your network.
Okay, no, that's not exactly correct.
Okay.
So in our, during the litigation and during discovery, the law firm was able to produce quite a few documents that had been downloaded from a peer-to-peer network. It was when we started looking through the piles of documents that we were able to ascertain what the likelihood is of which employee might have been producing most of those documents. And from there, we were able to then figure a timeline that, well, this employee doesn't currently have these documents on their current laptop. However, come to think of it, 2 years ago, their laptop had been stolen out of our clinic, and that's when we started moving backwards in that thought process.
Okay, thank you. I'm out of time, Mr. Chairman.
Thank you. If the gentlelady would just allow me to follow up on your line. Mr. Roessler, do you believe that Traversa provided you with all the information and all the files that they had found?
Could you repeat that question?
In other words, when they approached you and said, we found this vulnerability, do you believe they, at that time, they provided you with a sample of what they had found or all of it so that you could figure out the source of the breach?
Thank you, Chairman. That's a very good question. They produced one document, what I believe to be, it is my opinion, but that they had more than the one that they described to us that they had at the time.
And I'll go to the ranking member in just a second. The reason I want to do that is Ms. Duckworth's two different documents, since our data that's been found in discovery shows that Traversa did turn over to the FTC the documents, or we have a list with your name and so on it. It appears as though what FTC brought you, which was a different document, was also from the same source of Traversa. And Ms. Duckworth, the reason, and I appreciate that you're talking in terms of looking at Traversa and so on, is as far as we can tell, the only taker of this personal identifiable information that we know for sure reached in to his systems on his network and pulled out files was Traversa, who reached in, pulled them out, and turned them over to the FTC. That's the part that we know, is that at least one company found the vulnerability, took the information, gave it at a minimum to the FTC, and there is some question by the committee as to how the law firm got that same list and produced a class action, a law firm in the same city. And that's, I think, what the gentlelady is really looking at, is this doesn't look good, and the effects on Open Door were devastating.
Well, I would agree with the Chairman that the effects on Open Door was devastating, but I don't agree that they reached into their network. Open Door has determined that there was no breach of their network, and in fact, the data breach came from a stolen laptop. So if Tyversa got this information, they got it from someone else who uploaded the information from a stolen laptop 2 years prior to the Internet. It was not a breach of their network. They did a thorough search of their network, and in fact, Tyversa is getting this information that someone else, presumably the thief who broke into their facilities and stole their laptop, or someone that got that information off the laptop, uploaded it. So it's a two different mechanisms.
And I share with the gentlelady very much that versions of that possibility. That laptop that was stolen could have had LimeWire added to it. It could have been put up on the thief's Internet site, and Tyversa could have found it out in the Internet. The interesting thing was that Tyversa did not go to the laptop or to some other posting. They actually went to this company and said, we found the vulnerability on your site. And that's what is so perplexing, is they didn't say we found this information in the Internet. They went to Open Door and said, we found your vulnerability, and we offer you services for your vulnerability. Now, my understanding is Tyversa also will talk about helping cleanse lost data, clean up what's been out there on the Internet. There's a lot of services people talk about, but it is confusing that in fact this data, we know for sure, got into Tyversa's hands, and in our discovery we do not yet know, did they really get it off of your website at Open Door? Did they get it off the stolen laptop? One thing we're convinced about is that they may very well have never seen it somewhere in the Internet except on a vulnerability from a peer-to-peer, and in fact it may never have been made available so as to harm the 180-plus AIDS patients that in some measure felt offended and served in a lawsuit.
I would have to disagree with one portion of that, Mr. Chairman. I share your concern with Tyversa's very predatory practices, and I think we should look more into it, and I would love to have them here. But I think in this case, Tyversa said they found this data on a peer-to-peer network, not on Open Door's network. They found it on a peer-to-peer network. That's what they told Open Door. We found it on a peer-to-peer network. Open Door then went in and looked at their peer-to-peer network and saw and confirmed that it had not been breached and that there was no vulnerability in their peer-to-peer network. Just because Tyversa found it on a peer-to-peer network does not mean that that peer-to-peer network belonged to Open Door. Someone else uploaded it from likelihood that stolen laptop to a different network. So I just want to make sure that Tyversa is, they could possibly be trolling the Internet for this data on various peer-to-peer networks, not necessarily open secrets, found it and then tried to get them to purchase services. So it's two different things, and I just want to make sure that this is the things that Open Door has suffered has been because of Tyversa and Tyversa's actions with the law firm. And in fact, as far as the FTC is concerned, they sent them a note saying there's this form out there, there's this file out there, you need to take a look at it. And they've not prosecuted, they've done nothing else. Really, they've been the victims of a class action lawsuit that was initiated by Tyversa after they found a document on a separate peer-to-peer network that was not the one that was Open Doors.
You may very well be right, and I think you're getting a nod from Open Door. But I think the gentlelady has made the exact point that I hope we can all come together on, which is we have a whistleblower who wants to give us detailed information directly related to each of these events with actual recorded hard disk data, and only ask that his involvement and his testimony as to how he was involved in this at Tyversa not lead to his prosecution. And that is all that, in fact, when you see the proffer, if you will please see it, video proffer, you're going to see is a demonstration specifically of that, and it does give us a fact witness, however flawed in any other way, a fact witness who will make specific allegations as to particular companies and where their data was or wasn't. Additionally, and for me as a former ranking member and member of this committee, is also prepared to testify about evidence that was presented to this committee under oath, and that's why we have sought to have this witness. Today's hearing deals with what we know and what happened to these individuals and with some of the pitfalls of, does the FTC, for example, in the case of Open Door, did they get second corroboration, or did they send that letter, in your case, and a lawsuit in your case, based on a single source that may or may not have been accurate? And to a certain extent, I know we're all getting mired in Section 5 authority. This is more than Section 5 authority. It's about whether an agency, even if it has the authority, what are the safeguards before they file a lawsuit? What are the safeguards to make sure that the allegations are independently corroborated so that, because cybersecurity is, in fact, as the gentlelady knows, it's not a hard science where you can be sure. And if somebody says this happened, making sure it happened is important. So this is a broad subject. Cybersecurity is a core element of our oversight, not just here, but throughout government. And it's one of the reasons I thought bringing up the whole question of how do we move cybersecurity positively, because Mr. Hartzog, I think you would agree, and Mr. Stegmeyer, I think you would agree, that to the extent the FTC has authority, it's in order to protect against unfair practices, that's their basic, but in fact to move us into greater security and reliability of people's information when it's held by third parties. And that goes to the core of cybersecurity in and out of government. So my view was this hearing, separate from the other discussion that I hope to have with a whistleblower, this hearing was worthwhile not because there's an ongoing investigation or case, Mr. Doherty, and not because of what you've suffered alone, but because you're helping America understand this is complex. We have to make sure that allegations are correct, and we have to make sure that if there's a bad actor basically selling services in an unethical way, that we hold them accountable. And that's why I'm so interested in your line of questioning, and I support it and I appreciate it.
Thank you, Mr. Chairman. Again, I don't think the FTC filed a lawsuit against Mr. Roessler, just warned him that the file was out there. But I agree with you that I would like to know more about this process. It would be great if we could have the FTC here in testimony.
And we do intend to. What we're asking is that they answer our questions as to some of this corroboration and so on. We expect to ask both Tyversa and the FTC. One of the challenges, and I hope the ranking member will chime in on this too, Mr. Conley's statement about an ongoing lawsuit means that we have to think about how and when we would bring the FTC in so that we not put them here specifically talking about a lawsuit that is ongoing. So I want to be a little careful on that. We are working with the IG, and the FTC's IG is available to come in and brief your office because she has a separate investigation that we're respecting her ongoing investigation. Mr. Cummings.
Thank you. Thank you. Mr. Chairman, I want to just go back to something you just said, and I want to direct this to you, Mr. Herzog. When the Chairman, and I think when you boil a lot of this down, this issue of independent corroboration and trying to be fair, and I think that's what the Chairman is saying. He's not, I think he's saying that, there may be appropriate times, but trying to have a sense of fairness with it all, because these gentlemen, I think, would say that they feel that they have been treated unfairly. So can you talk about how that would work, and do and how other agencies deal with that? You understand what I'm saying? So,
Sure. So it's difficult for me to speculate on the way that other agencies deal with that, but I will say that it's important to remember that when the FTC gets information about a potential breach or vulnerability, that's just the very beginning of the inquiry. right? So the FTC doesn't police data breaches. The FTC polices unreasonable data security practices. Now, a breach can be evidence of a data security practice, but that's just the starting point, right? So if you look at the complaints actually have kind of a litany of data security failures, so failure to have a training program and failure to implement administrative and technical and physical safeguards. And all of these things are things that are incumbent upon the FTC to actually prove if they allege them in the complaint. And so I think that we want to be careful not to assume that just because the FTC has been notified of a breach, that immediately means that the company that that suffered the breach is liable, right? So the FTC, it's on the FTC to fill that out, right? To say, well, what actually were there unreasonable data security practices that allowed this breach to happen, or was this a breach that's going to happen regardless of whether there were reasonable data security practices? And that, to me, is really where the FTC, starts doing its real investigative work, and that, the notification of a breach is just kind of the first tip that leads to an investigation.
Thank you. Mr. Clay.
Thank you very much.
Thank you, Mr. Chairman, and thank you for conducting this hearing. Some critics of the FTC's approach to data protection have argued that the FTC has not provided adequate notice of the guidelines a company must follow to avoid an enforcement action. For example, in federal litigation in New Jersey, Wyndham Hotels argued, and I quote, "If the FTC can regulate data security at all, it must do so through published rules that give regulated parties fair notice of what the law requires." Professor Hartzog, do you agree that published rules are required to give organizations notice of the data security standards that are required?
I don't think that that's necessarily accurate. I think that administrative agencies like the FTC actually have the choice of publishing rules or proceeding in a case-by-case basis and establishing the contours of the law on that way. And in this instance, when you have a complex and ever-evolving problem like data security, which is really more of a process than a set of rules, then the FTC has chosen, and I think probably wisely, to proceed in a case-by-case basis in order to incrementally establish rules and be adaptive to the ever-changing needs of consumers to have their data protected.
Well, how can a company know when it's going to run afoul of the data security requirements if they don't have notice of the rules?
I would actually argue that they do have notice of what's required. So there are several different things that you can look to. When you have a reasonableness approach, the FTC isn't the only agency, or the only regulatory scheme that uses a reasonableness approach. So states do, and there are other statutes that take advantage of it. And you can look to basic things, right? So even in the statement that the FTC issued on its 50th data security complaint, let it know that there are really 5 basic things that you have to do. You have to identify your assets and risks. You have to minimize data. You have to implement safeguards. And you have to have a breach response plan. And those are the basic components. And the way that you then fill that in is you look to lots of different variables, like the size of the company and the sensitivity of the data and the amount of data that you're collecting and the resources that you have available, which of course vary wildly according to company. And so it actually, I think, would be a mistake to try to put those into rules, because they inevitably would be either over-inclusive or over-protective or under-inclusive depending upon the context. And so really the only way forward is to, in my mind, is to proceed upon a reasonableness basis here.
Okay, other critics of the FTC Section 5 Enforcement Authority have argued that the FTC should establish bright-line data security standards in advance of any enforcement measures, delineating exactly what companies must do to comply with its data security obligation. Professor Hartzog, in your recent article on the FTC and data protection, you addressed this point, writing, and I quote, "Many critics want a checklist of data security practices that will provide a safe harbor in all contexts, yet data security changes too quickly and is far too dependent upon context to be reduced to a one-size-fits-all checklist. Professor, can you elaborate briefly on what you mean here? How is data security changing in ways that make formal rulemaking impractical?
Sure. So I've spoken with a lot of data security professionals in doing my research, and they almost uniformly tell me that you can either have a one-size-fits-all checklist that lists the 17 things that you're supposed to do, or you can have good data security, but you can't have both. And the reason why that is that data security changes so much, and it wouldn't make much sense to say that small businesses have to follow the same data security protocols that Target and Amazon have to follow. And so it actually is very dependent upon all these variables. And to the extent that we've heard testimony today saying that, oh, well, we have guidance from HIPAA and we have guidance from Gramm-Leach-Bliley, I would ask everyone to actually look at the complaints filed by the FTC. They're very similar to the requirements in HIPAA and Gramm-Leach-Bliley. And so to the extent that everyone is kind of fine with the way that those work, I think you can see similar kinds of requirements in the complaints filed by the FTC.
And you also wrote that flexibility to adapt to new situations. The FTC can wait until a consensus around standards develops and then codify them as this happens.
That's correct. So one of the problems with formal rulemaking is that if you make it too technologically specific, then by the time the rule actually gets passed, it's become outdated and you've got to start the whole process all over again, and then it becomes this never-ending series of trying to update standards that have become outdated. We've actually seen this in other areas of the law where we've tried to list out technological specifications, and we now get routinely frustrated that that they're outdated because it changes so quickly.
Well, thank you for your response, Mr. Chairman. My time is expired.
Thank you, Mr. Clay. Well, we're going to come to a close, which is probably blessed for all of you. But I have just a final set of questions, and I'm going to go to each of you. Mr. Hartzog, I hear everything you're saying, but if I'm to believe what you're saying, the complaints and the consent decrees are supposed to be my guidance as to what I have to do. I have to find within the complaints a company and a set of information that's similar to mine to figure out what I should or shouldn't do. But even then, the consent decree says we're going to keep an eye on you for 20 years. So 2 years later, 3 years later, what they're doing behind closed doors in their oversight of that one company, I don't have visibility on that. So how am I supposed to know what the law is?
So I would actually say, instead of looking kind of to the consent decree, you look to the complaints, and the complaints actually point to industry standards, right? And there are various actually standards you could look to. So you could look to...
But none of those standards are safe havens, is that right?
Well, no, not explicit safe havens, but I think the understanding...
But wait a second. If I go 34 miles an hour in a 35-mile-an-hour zone, I'm not going to get a speeding ticket. Is that right?
I'm really glad you brought that up. So Mr. Stegmeyer brought up the whole speeding limit thing as far as how that's adequate notice. I would also add that if you look at speeding rules, in inclement weather, the speeding rules actually change. They say drive reasonably under the circumstances. And yet we don't have a problem with that speeding law, which is, of course, based on a reasonableness standard.
That happens to be an interesting law because it only gets enforced when you have an accident, and then they will sue you. They will claim that you were driving too fast for conditions. I appreciate the fact that you noted then that when the fit hits the shan, when things go bad, I worked on that for a long time. I want you to appreciate that. Then they will write you a ticket when, even when you drove the speed limit, something happened. But there has to be a bad occurrence for that to be enforced. So I think we're all agreeing it's a good example. But cybersecurity is a real question. I don't know everything about LabMD. I don't know everything about Open Door. But I will tell you that people right now, whether they have a server in a closet and they're buying the latest software from Microsoft and other companies, or they're up on Amazon or somebody else's virtual network, they don't know what the standard is. I know one thing. Target and the U.S. government at healthcare.gov spent millions of dollars on security, hired countless experts in and out of house, and they were obviously data failures. So it's an inexact science. The Federal Trade Commission has a mandate to protect us as consumers from effectively willful or reckless behavior. LimeWire participated in reckless behavior in the switches, how they had them turned on, what the default was, perhaps even on the peer-to-peer, but certainly because they made you most vulnerable unless you knew a lot about the software and installation, they created a vulnerability which, quite frankly, was intentional. And in a hearing before this committee, we pretty much got that they thought it was great to open wide when, in fact, they were implying it was small. To me, that's what the Federal Trade Commission was supposed to go after. They just weren't apparently an easy enough target. So as we look at not Section 5 authority, because I believe that Section 5 authority intended on deceptive and unfair practices in the Internet world, in the cyber world, being an authority. I think they did. But I think they wanted us to go after LimeWire, after people who claim things. And quite frankly, I think maybe they want to go after a company like Tyversa, who goes around and trolls all over the Internet using expertise that some might say was similar to the CIA, who, by the way, paid Tyversa at one point. And they go out and they find all these vulnerabilities, and then they turn them into business practices. And in fact, every indication is they not only found the vulnerabilities, but they stole information off those products. They stole them after the CEO of that company testified that these people were victims. Mr. Bobeck testified before this committee that people whose employees loaded LimeWire were victims, that in fact the person loading LimeWire was a victim because he or she didn't understand that they were creating the vulnerability. So the very person who said you're a victim of this peer-to-peer software before this committee then used that vulnerability to pull data, to steal data. And to the extent they stole data only so they could inform the company and show them that it happened, I might say that it wasn't wrong. But to the extent that it was $475 an hour, that becomes a little more questionable. To the extent that they then go to the FTC if you don't say yes, as though they have a civic obligation. Our discovery is not finished. But at this point, it appears as though if you paid Tyversa, you never would have gotten that letter from the FTC. Mr. Doherty, if you paid Tyversa, you never would have had these years of agony, and for just a few $100,000, you probably would still have a going concern instead of litigation ongoing. Now, that doesn't go to the merit of the letter. It doesn't go to the merit of the suit. It goes to the whole question of the practice. We haven't passed a law that says if you go out and surf the Internet, look for vulnerabilities and take things off of people's private sites, including HIPAA-related material, that in fact you're a criminal. Maybe we should. And that's within the jurisdiction of Energy and Commerce and other committees, and we take it seriously, and it's one of the reasons that this hearing is important. Now, I have a closing, very self-serving question, mostly for, if you will, my two company victims. Things have been said here and allegations made and questions about Tyversa as a company. I don't normally investigate companies. It's not the practice of this committee. But given, and I'm going to leave Mr. Doherty because you're in a lawsuit. I'm just going to leave you out of it for a moment. But, Mr. Roessler, your case is completely finished. Is that correct?
It is.
And so you're done. You have no financial interest in anything that we look into. Isn't that correct?
That's correct.
So do you believe it's reasonable for this committee to find out what Tyversa took off of your website or your site or some other site, where they got that information that they approached you with an offer to sell you services?
I believe it's worth the while if it is a pattern that I am not the only victim, then it's worth the while.
If we thought you were the only one, we wouldn't be here. Do you believe it's important for us to verify the relationship between Tyversa and the various companies, many of whom we have lists of, so we know you're not the only one, that they turned over to the FTC based on one question? The ones that they offered services to that bought the services, where they never turned over to the FTC, well, ones who declined were often turned over to the FTC. Is that a question you think we should find out the answer to?
I believe that would be a very good question.
And lastly, the law firm that sued you in a class action, do you believe it's fair for us to find out whether there was a direct connection between these two Pittsburgh-based companies and data taken from somewhere, yet unknown, provided to the law firm, and the law firm then going out and reaching out to your patients and clients? Do you believe we should ask those questions as part of a broader investigation to find out whether, in fact, that was coincidence or, in fact, an attack on your company because you didn't buy their services?
Mr. Chairman, one of the reasons why I'm glad to be here today is the hope that possibly that question could be answered.
Well, I'm going to recognize Mr. Cummings. These are some of the areas in which I believe that somebody should investigate. For now, the somebody is us. Our hope is that the FTC-IG, who has some authority, but not as much as we do, oddly enough, to get information from non-government entities, and perhaps the Justice Department and others will look into it. But until we find somebody else, at least for the foreseeable future, my intent is to continue asking those questions. We will invite Tyversa and others in. As I said at the opening, I would hope to hear that all the members would hear from the whistleblower, not because his accusations are alone of anything other than the basis under which we began this, but because when you get one set of allegations and you go out to corroborate them and you have those as a first statement, then when you find the second corroboration, normally it allows you to show that it is true. I want to get to the truth. I know Mr. Cummings does. So for all of you, Section 5 authority, it's not our job to second-guess what Congress gave them. They gave them the authority. Section 5 authority, it is for us to ask, are they acting in a way that allows unfair actors to be held accountable and others to know how to meet their obligation? You have our commitment. We intend to continue and do it. As to unfair practices practiced in the cyber world, and as to people's vulnerabilities and how they correct it, this is an ongoing part of this investigation. What the questions I asked you, I said they were self-serving. It's the intent of this committee to continue for as long as it takes to feel that all parties are satisfied that we asked all the right questions and got as many answers as we could. Mr. Cummings.
Thank you very much, Mr. Chairman. When first of all, I want to thank the witnesses for being here. You know, sometimes I think witnesses wonder whether they have an impact, and I can tell you that all of you were excellent, and I really appreciate what you said, and I think the members listened to you very carefully. When I first read the title of the hearing, I was very concerned with, and that question of whether FTC has the authority to pursue data security enforcement actions under its current Section 5 authority. And I think, based upon what the Chairman just said, I think we all agree that they do. And I agree with him. The question is how they go about doing that. And I think that there are moments that present themselves in our lives where we have to stop for a moment and at least take a look at what we're doing and how we're doing it. Mr. Rossler, Mr. Doherty, as I said before, if you've been treated unfairly, you know, and both of you are dealing with, your businesses dealt with health issues, right? Right? Health. And health is a big, big deal for me personally, and I'm sure it's a big deal for most of us. And so, but I want us to be very careful. You know, government does have a role to play. It really does. When people's information is out there and their lives can be turned upside down. I've had people to come to me as a congressman talk about their identity being stolen and taking years and years to get it back. We have to have some folks making sure that we protect as best we can against that. And I think that, but there's always a balance. You know, there's got to be a balance so that we don't just run over people like you, Mr. Ross, or you, Mr. Daugherty. But at the same time, make sure that folks who are aiming to do these kinds of things know that we're not going to stand for it, and that somebody's going to be looking, and somebody's going to bring them to justice. So that's where, you know, that's, you know, if you listen to everything that has been said here today, I think that's what it pretty much boils down to. How do we strike that balance? And so I thank you, Mr. Chairman. I think it was a good hearing. I look forward to hearing from the FTC. And you're right, trying to hear from the FTC is going to be kind of tricky, because it seems as if, I mean, if you could limit the questions to their general procedures without getting into the case, I think that might be helpful. But it's going to be tricky. But I think we do need to hear from them as to how they go about this. But again, this is a critical moment. And I think we need to try to take advantage of it so that we can, if something needs to be corrected, that we correct it. I think anybody wants to have some idea of what they're being accused of. I mean, well, if there's ways to get the information out in a better way, you know, this is what you need to look out for. It's just like when you're riding down the road and it says, you know, 25 miles an hour, radar enforced, by photos, and, you know, I mean, at some point, it's nice to have a little notice, and all of us know after we've gotten a ticket or two that we slow down. And we know those areas by heart. We just know them. And so, again, I thank you all for your testimony. I really, really appreciate it, and thank you.
Thank you. I'll leave the record open for 7 days, not only for members to put in opening statements and extraneous material, but for the witnesses to provide any additional information they deem appropriate as a result of the questions here. I want to thank you for your testimony. I want to thank you for making this a worthwhile hearing, and we stand adjourned.